I'm just in the process of letting people join, so bear with me while I try to get everybody in. Good Lord, it just takes forever. All right, let's see. Mr. Gardner, did I see you on here? From the Commonwealth?
I'm here, Judge.
Yeah, do you have any order? I know I've got the Allen County Jail on here. I believe it's possible. Guys, mute your device, please. I've got, I think it's Miss Williams in Allen County. I don't think I have anyone else in Allen County, so I don't know if we're in a position to try to go ahead and take that one up so I don't tie that facility up any longer than they need to be.
Judge, that is my case. I forget who's on the other side.
Judge, this was my case. It was still listed in my name as of today. I thought it had been transferred out of my name. So I haven't had any conversations with either Miss Williams or Mr. Gardner about it. So we probably need to push this off till I guess the 17th or the 24th to allow her new counsel to talk to her and talk to possibly resolving this case.
Denise, do you know who will end up with this one?
I believe it will be Zandy's.
All right. Not sure she's on here yet. I don't believe that she's made it into the meeting. Okay. Josh, is this one, I was thinking, does she just have like several other counties involved in charges?
I think at last check, last time I spoke to her on the phone a few weeks ago, I think she had pending cases here, Allen County, and I want to say maybe Warren County as well. But definitely not here in Allen.
All right. Well, Denise, what I'll have to do is go ahead and I'd like to go ahead and address her situation just so that I don't have the Allen County Detention Center there tied up. So let me just pass her over to, we look at May 24th, which is a month. And that ought to give Miss Myers time to dig into it and see if there's anything that she can accomplish. So that's 5-4 at 1 o'clock.
Can I get the number for the public defender's office to call from the jail, please?
Yeah, Marianne, you got something to write down with?
Yes, sir.
All right, it's 833-385-6055.
And is that the one to call from the jail?
No, she needs the jail line, the 502 number. Do you have one of your business cards with you, Josh? It's on there.
Yeah, I've got one here somewhere. I did.
And what's the new attorney's name?
Xanda Myers will be your new attorney.
Thank you.
Okay, Marianne, the jail number is 502-564-5655. 4211.
All right, thank you.
All right, so we'll try to go ahead then and pass this over to May 24th. And we'll let Ms. Myers know that she's going to be handling it, and we'll see whether there's any progress that can be made before we come back, okay?
All right,
Thank you, Judge.
thank you.
And Judge, in my notes reflected, I've given offers in these cases. Denise, obviously, if Xanda doesn't see that in the file, let me know.
All right, good deal,
Yes, sir.
good deal. All right. Mr. Gardner, we have obviously plenty of people to choose from here. I don't know. Oh, I see. Mr. Simpson, who do you have?
Judge, I've got Michael Bruton, who is in jail.
Yeah,
And then I've got Stephen Tang, who we've sent the plea agreement to. We've been having trouble with DocuSign. So he's in the midst of trying to sign that and get that back to us. And I don't know if we'll get that accomplished in time to enter that plea today or not.
yeah. Well, we're gonna be here for a while, so if he's able to get on probably before dark, we'll
I
probably.
think he may be the Galaxy A01, but I'm not sure. I'll probably, what time will you be doing the jail?
You know, I can't promise any particular time, but I would guess that it'll be at least an hour or so from now, if not longer.
I'll probably hop off and do a couple of other courts and come back then.
Yeah, that's fine.
Thank you, Judge.
Yes, sir.
Judge, I do see Lacey Andrews on here. She's a special prosecutor in the Walden case.
Okay.
I don't know if there's anybody needs to
Hi,
be here.
Judge. Yes, I
Hi
think
there.
I saw Ken Garrett on here as well.
I'm here.
Yeah,
Okay.
Ken's on here.
I am. And Crystal is here as well.
Okay.
All right, so she's with you, Ken.
She is, Your Honor.
All right.
Judge, this case, oh,
go
go
ahead.
ahead.
No, that's fine.
This is set for a pretrial conference today. I think that we, up until this point, we've been waiting to see if Ms. Walden was going to be evaluated, and she has. And we have that report, and I think that Mr. Garrett does as well. We just hadn't, I don't think we've been on the docket for a couple months now, and I wanted to kind of keep the court up to date on what we're doing in the case. I think we need to set another date for a pretrial or possibly for a competency hearing. I'm not sure where Mr. Garrett is with that.
However we need to set it, Judge, is fine with me.
Well, are you going to, do you want to have a hearing and hear from the doctor on this competency question, or do you want to just stipulate to the testimony being consistent with the report and I read it when it came in, but I haven't looked at it since.
I can do that.
In a minute.
I can stipulate to the document being what it is and let the court decide from there.
Okay, so.
Judge, we are fine with that. I have no objection to it. Just ask that the report be placed in the record under seal for you to place your finding on.
Yes, ma'am. It has been filed in the record in a sealed envelope. So of course I'll need to open it back up so that I can read it. And then I can get an order to everybody. I'll try to get to that as soon as I can. But it'll be a minute or two. Folks, mute your microphones on your devices, please, if you're not in the hearing. So Mr. Garrett and Miss Andrews, moving forward here, then I guess you all probably just need me to set this for a pretrial conference, and it needs to be enough time that I've done this order and you all can see what the order says and all of that. Which I think I should be able to, knock on wood, but I think I should probably get to it this week. It's not a great big report or anything. It's something that, it can go take very long to read once I get to it.
Yes, Judge. Yeah, I think that we could go maybe about a month out. While we're here, Ken, I had asked you a question about discovery to make sure.
Yes.
to send you anything else in the meantime. Did that yet?
You cut out a little bit. You had said that you had asked me a question about discovery. it cut out.
Yes. Do you have Miss Walden's interview with the detective in its entirety?
Let me
I'm a
double
little
check.
concerned you're missing part of it.
If you want to resend me a copy of it, that would be fine. I'm looking right now in my files to see if I have that.
Okay. I can send you another copy of it. It's no problem. Judge, I'm fine with going about a month out. I've extended an offer to Mr. Garrett. I know we'll need to get the determination of competency, the order on that, but a month is fine with me. If that's fine with Mr. Garrett.
That's fine.
Yeah, all right, so let's look at, you want to look at May 24th?
May 24th would probably work, Judge. If it doesn't, I've got a trial set, but it may end up getting continued. If it doesn't work, then I'll just get in touch with Miss Andrews.
That's a good date for me, Judge. Will that be in person or via Zoom?
Well, I'm hoping that we can do it in person as long as it's okay with everybody. You know, these we're looking at these on a case by case basis, but usually if the attorneys are okay with doing the things in person going forward, I think it's better for everybody. So I would
Sounds
like
good.
to do it in person if I can.
Yes, that's good with me.
All right,
That's fine, Judge.
5/24 at 1 o'clock.
Yes, sir.
All right.
Thank you, Judge.
Thank
Thank you,
you.
Judge.
Have a good day. Let me, I believe Mr. Simpson got out of here before Mr. Tang got in here, so I wanted to tell him that, because I saw him join a second ago, that Mr. Simpson was here, and because he said you all were having some difficulty with the DocuSign, he was gonna go, he had to go do another hearing, and then he was gonna come back. So if you can just sit tight till he gets back in here, okay?
Yeah, that's fine.
All right. All right, let's see. Any attorneys want to identify a particular case that they would like to take up?
Your Honor, I know
Yeah.
that Ken is on here. I don't know if you had mentioned that, but David Franklin is on. We still have some ongoing negotiations and don't have a resolution. I wanted to see if we could maybe put this on May the 24th. I think that might allow us more time to try to see if we can get this resolved.
That'll be fine. Thank you, Risa.
May 24th?
Yes, Your Honor.
Is he on here, Ken?
He is not, Risa. I had already intimated to him that it was likely to be continued, and I would let him know what the new date was. And I will get that proposal to you today or tomorrow.
Yeah, I need that this week, please.
I will definitely get it to you.
All right.
All right, so we'll push this one over to May 24th and get back together on it on that date, okay? All right,
Judge, while we're doing Ken's cases, he's also got Dusty Whitlow, who's on here as well.
okay.
And Ken sent me a text this morning about the plea offer. There's one issue that's outstanding, and I've got to do a little, I guess, a little research on that and get back with Ken on it. So we probably need one more pretrial conference, and we should have it resolved at that time.
And John, he has signed the paperwork, and I'll hold that until we resolve that other issue.
Okay.
So we could just delete that if that's something we can do in the future.
Understand.
Thank you.
All, would you be okay with moving this one 2 weeks? Which is May 10th?
That's fine.
that work for you, Mr. Gardner?
It does, Your Honor.
All right. May 10th at 1 o'clock. And again, Ken, I'll plan on doing that in person unless you all object somehow.
Yes, I'm fine with, I prefer to be in person. That's fine.
I think that almost everybody does. Dusty, you on here?
Yes, sir.
Yeah. See you May 10th. That's 2 weeks.
All right, that's fine.
1 o'clock
All righty.
up here in person.
I like it better.
Yeah. All right. See you then.
See.
Thank you, Judge.
You're welcome. All right, let's see. We got Terry Alexander on here, I saw. I'm just going alphabetical down my list now. Unless
You have
you
an
all,
agreement, Judge?
anybody that wants to pop off a name, do that. But until we do that, I'll just start going. All right, Terry. Where are you? Where'd you go? There you go. Okay. Your video quit working.
Okay.
All right. Hey, folks, turn your microphones off until we get to you. All right. For you. All right, Terry. So you all have something worked out in your case?
I believe so.
Okay. Would you raise your right hand for me? You swear to tell me the truth, so help you God.
I do.
All right. Let me get up here where you can see me. Well, not me, the paperwork. All right. This is a motion to enter a guilty plea. It's got your name, case number, et cetera on it. Does that look familiar to you?
Yes, sir.
And there is a signature page right there. Is that your signature?
It is.
Okay. The Commonwealth has put an offer in writing and it's right here. Does that look familiar to you?
Yes.
Okay. Is that your signature?
It is.
Okay. Did you read both of these before you signed them?
Yes, I did.
Are you comfortable that you understand what you have signed?
Yes.
Did you have time to discuss matters with your attorney? And are you satisfied with the amount of time and the discussions that you all have had?
Yes.
All right. Terry, do you understand that you cannot be forced to enter a plea of guilty, and that if you do enter a plea of guilty, you have to do so of your own volition, voluntarily? You understand that?
Yes.
Okay. Do you feel like you are being made by me or by anybody else to plead guilty?
No.
Okay. You understand that you waive the following rights if you plead guilty. You waive the right not to incriminate yourself. You waive the right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt. You waive the right to confront and cross-examine the witnesses that give evidence against you. You waive the right to put evidence on in your defense, and you waive the right to appeal.
Yes.
Okay. Now, today, as we find ourselves here, do you feel like your judgment is impaired for any reason, or that you're having any difficulty either understanding me or exercising your decision-making?
No.
All right. You feel comfortable that you understand what you are doing and that you are able to communicate adequately with me?
Yes.
Have you been able to adequately communicate with your lawyer?
Yes.
Okay. In this case, the Commonwealth has made you an offer, and you and I need to talk about it to be sure that that we all understand one another. Okay.
Okay.
Your original count one was trafficking in a controlled substance, first degree, more than 2 grams, first offense. That is a Class C felony. The Commonwealth's offer is to amend that charge to possession of a controlled substance, first degree, second offense, which would, and on a plea of guilty, would result in a recommendation of a 3-year sentence. Count 2 is possession of drug paraphernalia. The Commonwealth agrees to recommend a 12-month sentence. Count 3 is persistent felony offender in the first degree. the Commonwealth agrees to dismiss that charge. The total recommended sentence would therefore be a 3-year sentence, and the Commonwealth would agree to probate that sentence under supervision of probation and parole for a period of 3 years. Do you understand the offer the same way I do?
Yes, sir.
Okay. Other than what you and I just talked about, has anybody promised you anything in exchange for a guilty plea?
No,
Has anyone threatened you to try to get you to plead guilty against your will?
no,
Are you in fact pleading guilty voluntarily and of your own free will today?
yes,
All right. Harry, are you acknowledging to me that on or about the 25th day of April, 2018 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine, having a prior conviction for possession of methamphetamine or possession of a controlled substance, and that you possessed drug paraphernalia?
yes,
All right. I am going to accept your guilty plea today as having been made freely, knowingly, intelligently, voluntarily, with advice of competent counsel. Let me ask you, you're not on any probation anymore, are you?
yes. I still have like about about 2 months left on it, I think.
Oh, okay.
A little less than 2 months.
Okay. Well, that's going to work out because under those circumstances, if you want to just go ahead and get sentenced, I will do that since you're already on probation.
Yeah,
And
I do.
not have to do a pre-sentence investigation and report and sentence you on a separate date and all that.
Yeah, that's fine.
All right. Then that's what we're going to do. Okay.
Okay,
I'm going to accept your plea of guilty, and I'm going to sentence you in accordance with this agreement, which is a 3-year sentence. I'm gonna waive your fine and costs. Who's your probation officer?
down here in Bowling Green, it's Lauren Wilson.
All right, all right. Who do I have on here today from probation? It was
It's me, Judge.
still you.
It
Okay.
is. All
Well,
right.
I can't find you on the screen, Officer Bray.
Hold on, man.
No, you don't have to turn your camera on. I just was looking for your name. There it is. All right. So Terry's already on probation and being supervised out of Warren County. What are your reporting instructions to her here?
Well, Lauren Wilson is out at this time, so she needs to call down there immediately after court and talk to Assistant Supervisor Watt, W-A-T-T. Just
Right.
talk to him, tell her what's going on. I'm gonna put a note in our system about what happened, but go ahead and tell him, so he'll hear it from you.
Okay,
All right. So Terry, you'll take care of that as soon as you get off here and then just report as they tell you to. And you should be good. Okay.
okay.
Do you have any questions?
I don't,
Listen, I'm glad you've taken care of this and, gone through your treatment and all that stuff. Let's just keep up the good work. Okay.
okay. All
All right.
righty.
Hang in there. We'll see you.
Okay, thank you.
You bet.
All right.
Your Honor, this is Ronnie Whitaker. We were Shelby County.
Yes, sir.
I was just letting you know we're on.
All right. Well, I tell you what, can you remind me who you have? Cody Holly?
Yes, I do, Your Honor.
All right. Well, why don't we just try to go ahead and talk to Mr. Holly?
All right, he's right here.
Yes, sir.
All right. And for those of you that are listening, I also have Mr. Alonso on here at, where are you, at Roder? So we can do him next. Everybody can get ready. Mr. Holly, you're here
Yes, sir.
on 2 different cases, 20 CR 128 and 20 CR 200. I believe that those are both scheduled for an arraignment. I don't think that you have been arraigned after your indictment in either one of these 2 cases. Are you going to need me to appoint a lawyer for you?
Well, sir, I could afford a lawyer if I get my, my bond and stuff dropped. But see, I got my tax check is out there and I can't get it cashed unless I get out because it's $5,600. And if I could, get out, then I could cash that and then I could get me a lawyer, but that's the only way I could do that.
Well, are you in jail up there? Do you have
Yes.
additional charges in, is it Anderson County?
Yeah, I'm finished here today.
You finished?
Yes, sir. And I was doing good out there and everything. I was getting my daughter back and everything, and I lost custody of her, but I was in the process of getting her back. And I have, like, as soon as if I get out, then I can get her, like, start getting overnight stays and all that stuff.
So who's got this case for the Commonwealth? Is this you, Mr. Richardson?
It is, yes, Judge.
It might, I don't know if it's too much to, well, I can ask and you can tell me you don't know. Do you have any idea what's going on? Does your understanding go along with that he's finished up in?
Well,
the case?
he's
Or do
got
you
a Anderson County charge, but what kind of gets me concerned here is he was indicted on this charge back last June. And the charge that he was charged with in Anderson County was a misdemeanor, but it was for giving an officer false identifying information. He had the active warrant, which I'm assuming was from this case, and he lied to police about who he was. So I've got concerns that if you amend his bond, he gets out, he's going to be a flight risk.
No, sir.
He's also facing a Class C felony with a PFO first. So I mean, these are pretty serious charges, and he's he's obviously got more than one felony on his record. So I've got some concerns here.
No, sir. I actually was living with my daughter and everything in Lawrenceburg, but my stepmom and my dad, they're gonna actually like be my support system, and they're church going people and everything, and they want to help me and everything. And it's I can give you the address. It's 302 Coral Hill.
I'm not worried about them, but
Nody, what address will you be staying in if you get out?
302 Coral Hill, Lecter Road in Glasgow. That's my stepmom and dad and my granny. They're actually living with my granny. The one's got she's got dementia, and they need somebody to stay there and take care of her while they work and stuff. But like one's got to stay there, and then they got to they run a paper route, and one's got to just run the whole paper route the whole time. But now they usually do it together. But
all right, hold on now. Listen, just give me what I asked for, okay?
Yes, sir.
All right. Well, here's the situation. I don't know if you're able to employ your own attorney, I would like for that to happen and take some of the weight off these public defenders that have too many cases already to begin with. And I don't know what led to all this, but you've been in jail for almost a month now. For lying to the police or whatever it was that happened. So, I mean, listen, I've been knowing you a long time, and you know that, when I let you out, I mean, if I change your bond and get out and I tell you to come back to court and so forth and so on, I mean, I'm going to expect you to do what I tell you.
Yes, sir. Yes, sir. That's totally fine. I don't have no reason to not come to court now. My little girl, you know what I'm saying? I'm trying to get custody back, my little girl.
Listen, that's fine. All right. Just let's keep it between the ditches. Okay.
Yes, sir.
All right. But here's what I'm going to do. When you were originally charged on this trafficking case in district court, you were on pre-trial monitoring with the U-turn, and that's why you have a warrant, is because there was a violation of that. I don't know I can't recall what it was because it was a year ago. But I mean, by the time you got indicted, you had a warrant pending out of district court. So I just kept a warrant on you. And, I don't know what was going on, and I don't need to know because, I'm going to give you another bite at that apple. But how you going to get down here?
Actually, my stepmom and my dad was going to come and pick me up as soon as I get out, or my mother-in-law and father-in-law was going to take me down there.
So you're telling me that if you can make bond in these two cases, you're not being held, you got a time served or something out of Lawrenceburg, right?
Yes, sir. Today's my last day here.
All right. Here's what I'm going to tell you. I'm going to go back to what your original bonds were going to be here before you messed up. And that was going to be on the 20 CR 128. That was a 5,000 unsecured is what you would have had if you hadn't messed up. And the 20 CR 200, that's the possession. That was going to be a 1,500 unsecured. So listen, I'm going to let you make those bonds on the following conditions. The first condition is that you're going to have to get in touch with these U-turn folks to do the pretrial monitoring that you were supposed to be doing. And because I don't know when you're going to get down here, I want you to get in touch with them by the end of the day tomorrow. All right.
Sure.
So that is, that's going to give you time to get down here. If you have to make a phone call instead of going in person because you can't get here in time, that's fine. But then they'll make an arrangement for you to come in person. All right. The other thing I'm gonna tell you is that, and you know what, all of this, but you need to contact, or, you know, if you're gonna get an attorney, you need to go ahead and take care of that. I'm gonna put you on for a arraignment in about a month so that you can get your attorney and report in here, and we'll try to arraign you. You need to stay out of trouble.
Yes, sir.
No drugs and alcohol.
No, sir.
Report to U-turn, right?
Yes, sir.
No new arrests.
No, sir.
All right. So I will reinstate those bonds as mentioned, and we're gonna see how this works. But you know, I mean, you know what's gonna happen if you don't
Yes, sir.
straighten up. Okay.
Yes, sir. Yes, sir. I was doing good for a year anyway, so thank you, sir.
So I will see you on May the 24th at 10 o'clock a.m.
Yes, sir.
All right. Thank you.
Thank you so much.
Your Honor, will you be faxing that to the jail, his release?
Yes, sir. We'll get you a commitment order or something up there as soon as we can. Okay.
Okay, thank you, Your Honor.
Thank you.
May I be excused?
You betcha. Thanks. All right. Let's see. Let's try to deal with Mr. Alonso while we got the floor. Is that? Is that? I'm not sure who's gonna be representing you.
That's me, Your Honor.
Okay, thank you. Do we have anything to talk about here?
So I had actually made a proposed offer to Mr. Gardner. He came back with a response, but due to the way that you have to schedule conversations through Rotor, I haven't had a chance to put in another request for another visit with Mr. Alonso. So I was going to request another court date. He is presently serving state time, so we can actually push this out a little bit to give a little bit more opportunity to try to negotiate this with the prosecutor if possible.
Yeah, I know the communication's not the easiest thing in the world with everybody having to, you know, do it by phone and make appointments and all that. So, you know, I can work with you on that. Do you have a day in mind?
I'm okay with setting it out into June, Your Honor, if the court's okay with that.
Yeah, I mean, I can live with, Mr. Gardner, what do you think about June 14th?
That's fine with me.
All right, that's gonna get us, that's about 6 weeks or so. We'll do that at 1 o'clock on June the 14th, 1 o'clock Central Time. Okay, we'll follow up with the facility up there later and get them a link and a email confirmation and so forth. Okay.
Thank you, Your Honor.
All right. We'll see you then.
Hey, Judge, real quick, what was that pretrial date for Cody Holly? I missed that.
What did I?
Sorry about that.
May 24th, wasn't it? May 24th.
Okay, thank you.
And I didn't actually arraign him because he said he was going to employ an attorney. So it won't be really be a pretrial. It'll be an arraignment.
Okay, gotcha.
For him to appear with his lawyer.
Judge, I see Kayla Fugate on here. She represents Donna Bartel as conflict counsel.
Okay. Let me make sure that they know up there in Rotor that we're done. I think.
Oh, okay.
Mr. Alonso was our only client. So I don't want them to be sticking around if they don't need to. They're free to go. All right. We got Miss Bartel. I saw her come in a minute ago in the meeting. Ms. Bartel, are you with us? Well. Donna Bartel. I got nothing. All right. Ms. Fugate, can you kind of sit tight for a minute and see if she comes back in? She was in the waiting room at one point because I noticed that it was,
I'll call her and see what's going on.
yeah. I know she was trying to get in at one point. I thought she got in.
Yeah, I'll call her and see what's going on, Judge.
All right. All right. We'll be back.
Judge, we have an agreement, I believe, in Travis Cox.
Okay.
If Myers is ready.
Mr. Cox was one of my first people in the waiting room today. Mr. Cox, can you hear me?
Yes, sir.
All right. Is it true that you believe you've got an agreement here?
Yes, sir.
Will you raise your right hand, please? Do you swear or affirm that you'll tell me the truth, so help you God?
Yes, sir.
All right, thank you. Mr. Cox, this is a motion to enter a guilty plea that has been filed in your case. Do you see that?
Yes, sir.
Does that look familiar to you?
Yes, sir.
All right. Here is the signature page. You see that?
Yes, sir.
Is that your signature?
Yes, sir.
Okay, thank you. This document here is the Commonwealth's offer on a plea of guilty. Let me zoom it on in there. You see that?
Yes, sir.
All right. And this is the signature page for that. Does that look like your signature there?
Yes, sir.
Okay. Did you read over both of these documents and have the opportunity to discuss them with your attorney before you signed them?
Yes, sir. Several times.
All right. All right. So do you feel comfortable that you understand what you've signed?
Yes, sir.
Mr. Cox, are you having any trouble understanding or hearing me today?
No, sir. I hear you fine.
Okay. Do you feel like your judgment is impaired for any reason today?
No, sir.
Very good. Mr. Cox, do you understand that you have certain rights and those rights are waived if you plead guilty?
Yes, sir.
Okay. You have the right not to incriminate yourself or admit guilt. And of course, that is waived if you voluntarily plead guilty. You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt, which is waived if you plead guilty. You have the right to confront and cross-examine the people that give evidence against you, which right is waived if you plead guilty. You have the right to put evidence on in your own defense, which you waive by pleading guilty. And finally, you have the right to appeal the outcome of your case to a higher court, and you waive that right if you plead guilty. Do you understand?
Yes, sir.
Okay. Mr. Cox, do you feel like you are being made by me or by anybody else to plead guilty today?
No, sir.
Okay. In this case, your offer from the Commonwealth appears to be as follows, and listen real close because I need to make sure that we all agree on what this says. Okay. Your original count one here was trafficking in a controlled substance, first degree, 2 or more grams, first offense. The Commonwealth has agreed to recommend, to amend that charge to possession, first degree, first offense, and recommend on a plea of guilty a sentence of 3 years. Your second charge is fleeing or evading police on foot in the second degree, which is a Class A misdemeanor. The Commonwealth would recommend 12 months. Your count 3 is resisting arrest.
I believe that one was dropped.
Yeah, the Commonwealth agrees to dismiss. Count 4, possession of drug paraphernalia, a Class A misdemeanor. The Commonwealth recommends 12 months. Count 5, driving under the influence, second offense. The Commonwealth agrees to recommend a sentence of 6 months, plus a possible fine of $500 and service fee of $425. DUI counseling as provided by law, and a license suspension as provided by law. Hold on a minute. All right. The last charge is possession of marijuana, a Class B misdemeanor. On a guilty plea, the Commonwealth would recommend 45 days. The total recommended sentence, because all of these sentences would run concurrently with one another, for a total recommendation of 3 years, plus the possibility of fines and the DUI service fee and other DUI sanctions, as we talked about a second ago. There would also be forfeiture of cash on hand seized in the amount of $600. The Commonwealth agrees to probation for a period of 3 years under supervision of probation and parole. This sentence would be consecutive to any other previous sentence if you have any time on any sentences left. Is this what you understood your agreement to be?
Yes, sir.
All right. Other than what I just told you, has anyone promised anything to try to get you to plead guilty?
No, sir.
Has anyone threatened you to try to make you plead guilty?
No, sir.
You feel as if I am forcing you to plead guilty?
No, sir.
All right. Mr. Cox, are you telling me that you acknowledge on or about July 10th, 2020, in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine?
Yes, sir.
All right. That you, as a pedestrian and having the intent to elude or flee, you knowingly or wantonly disobeyed a direction to stop given by a peace officer who had reasonable suspicion that a crime had been committed. And by so doing, you created or caused a substantial risk of physical injury to any person.
Yes, sir.
All right. Are you also acknowledging to me that on or about July 10th, 2020, you possessed drug paraphernalia and marijuana?
Yes, sir.
And that occurred in Barron County as well, right?
Yes, sir.
Okay. And last but not least, are you acknowledging to me that on July 10th, 2020 in Barron County, Kentucky, you operated or were in physical control of a motor vehicle while under the influence of a substance or combination thereof that impairs your ability to drive, having at least one prior conviction in the 10 years preceding that event?
Yes, sir.
All right. So, Mr. Cox, I'm going to accept your plea of guilty today as having been entered into freely, knowingly, intelligently, and voluntarily with advice of competent trial counsel. Now, you were indicating earlier when I said something about any other time, you're not on any probation or anything, right?
No, sir. I completed all that.
All right. Are you, do you reside here in Barron County?
Yes, sir. I live in K-City.
All right. Fair enough. Here's what I think we're going to have to do. When did you go off probation? Has it been in the last 6 months or so?
Oh, man. No, it was a little after October last year.
All right.
Judge, it was November of 2019.
Oh, boy. Time
it's been longer than I thought.
Yeah. Yeah. All right. Well, Officer Bray, I was trying to see if I could figure out a way around, him doing another sentencing and all that, or another PSI, but I think it's been long enough. I probably need to have him report to probation and parole and get a pre-sentence investigation and report done.
Yes, sir. We're open today. He can report today.
Yeah. Mr. Cox, are you able to get over here to the probation office today?
Yes, sir. I got to wait till 2:30 till my kids get here, and then my wife can bring me.
All right. Will that be all right, Wes?
Yes, sir.
All right. So, Mr. Cox, here's what let's do. Let's have you report to probation and parole before close of business today. And
yes,
they'll probably just have to update some information. It shouldn't take very long because you've already been on with, paper with them before. And then we'll set your final sentencing out for, it shouldn't be, I'd like to think we could maybe do this on May 24th. That's a month. Because I don't think that they've got to get a bunch of information from you.
Okay.
So let's do May 24th at 10 o'clock, and we will see you then. I don't know how you feel about it with your sentencing and everything. If you'd rather come in person, we can do it in person on that day. If you would rather do it from, since it's a probation offer, if you'd rather do it from remotely, I'll let you do that too. I don't care.
Whatever works for you, really. I would just assume come up here because it's easier, but
yeah. Well, I figured you would. Almost everybody does when I give them that choice, So we'll do that in person on May 24th. Okay.
Okay. At 10 o'clock.
10 o'clock.
Okay.
Your Honor,
Yes.
Your Honor, part of the agreement was that he forfeit $600 of the, I think it was $1,165 seized. So he should be due back some money. I'm assuming that's going to actually, an order regarding that will be done at the final sentencing, correct? I figure that's going to be his next question, is when he's going to get that money back. So I just wanted to clarify, because we'll have that final sentencing, that order would probably be entered after that.
Yeah, just be sure that you remind me of that. His offer does say, I wasn't clear on that, and I probably didn't make it clear when I was talking to him, because I didn't know if that meant there was $600 seized or there was more than that seized, and he's forfeiting $600. So, I mean, if you'll help me remember so that I can make it real clear when we do the final judgment, and that way there won't be any questions about it.
Okay. All right. Thank you, sir.
All right. So you'll see probation and parole today. I'll see you May 24th at 10 o'clock.
Okay. Do I need to send my license in now, or do I need to wait till final sentencing?
Well, your license won't technically be suspended till I send it to you. So you just need to, if you didn't get a pretrial suspension, and it doesn't sound like you did.
I didn't.
Then you just need to bring that with you when you come.
Okay.
All right.
All right. Thank you, ma'am. Have a
See
good
ya.
day.
All right, let's see. I think I saw Mr. Simpson get back on here. I don't know if he's ready or not.
Judge, I'm on here. Do you all have the paperwork now? It was e-filed.
Can you check, see? Yeah, well, I'll have to get somebody to check on that, because I can't real easily check while I'm doing.
I see that it was filed.
Yeah.
I got an email, Alan.
We'll get somebody to print that out for us.
I could have somebody email it to you, or Risa might be able to just forward the email to you. You want to do it that
Do you want
way?
me to do that, Judge?
Oh, I'm flexible. I mean, not literally, but in a metaphorical sense.
Mr. Tang is on here. Saw it just a second ago.
Yes. Those things get filed, but until they get accepted by the clerk, they can't print them, and the clerk that would accept it is probably sitting right here running the recording machine. So she's going to try to do it. And then, does our printer work anymore? Okay. Either way, I think Mr. Tang's on here. I can go ahead and start speaking with him, and then hopefully, if I get everything comes in, then I'll be able to show it to him. Mr. Tang?
Yes, sir, I'm here.
All right. I'm having trouble there you go. All right. All right, sir, can you raise your right hand for me? Do you swear or affirm that you will tell me the truth, so help you God?
Yes, sir.
All right. Mr. Tang, so in a minute when I get these documents, I'm going to show them to you to confirm that they are the documents that you have signed. But in the meantime, let me just ask you, is it the case, as far as you are concerned, that you have reached an agreement whereby you will be entering a guilty plea to something?
Yes, I understand.
All right.
Your Honor, if it helps, the charges are all being amended to wanton endangerment first degree from criminal attempt to commit murder and tampering with physical evidence.
Gotcha.
I just sent you.
I've got his plea offer here. I don't have a motion. Is there going to be a motion to enter a guilty plea in there?
We'll get you one of those, Judge.
All right. But I do have his the recommendation, so I'll go over that with. All right. So, Mr. Tang, do you understand that you have nobody can force a person to plead guilty, right? In other words, you have the right to maintain a not guilty plea, and if you decide to plead guilty, that is a decision that is up to you and you alone.
Yes, I understand.
All right. Do you feel like you are being forced by me or by anybody else to plead guilty?
No, I don't.
All right. Mr. Tang, do you understand that you have certain constitutional rights, and those constitutional rights are waived if you plead guilty?
Yes, I understand.
Specifically, you have the right not to incriminate yourself, and if you plead guilty, you waive that right. Do you understand?
Yes.
Okay. You have the right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt. And if you plead guilty, you waive that right. Do you understand?
Yes, sir.
Okay. You have the right to confront and cross-examine the people that give evidence against you and the right to put evidence on in your own defense. If you plead guilty, you waive that right. Do you understand? Or those rights?
Yes, I understand.
Okay. And last but not least, you have the right to appeal the outcome of your case to a higher court, and you waive that right by pleading guilty. Do you understand that?
Yes, sir.
Okay. I guess before we wrap up, before we move forward, let me ask Mr. Simpson. I kind of hate to ask you directly, so I'll ask him, but Mr. Simpson, is your client going to be staying in Florida, or is he going to be coming back here?
He lives in Florida, Judge. The only reason he was up here that time was to get all of his stuff.
Yeah. Well, I'm trying to figure out how this probation is going to work, because normally what they tell me is that, once he gets sentenced, he'll have to come up here till they get him transferred to Florida. Now, if he already lives in Florida, it shouldn't be too hard. And sometimes it's just a matter of a day or two, but we always get a lot of grief if somebody lives in another state and they try to stay there between sentencing and getting accepted through that interstate compact.
Judge, I know that in Metcalfe County, we had a similar situation on a diversion, and Charity Ford helped us out and worked it out for that defendant. I can't remember in particular what was done, but
yeah, I don't remember either.
I think they contacted the Florida authorities.
Yeah. I guess what we'll need to do, that ain't gonna keep us from going through with this, but what we'll need to do is maybe get him off on another, maybe put his final sentencing off for another day, and after we wrap this up. And Alan, I don't care at all to do it remotely, and then we can try to work with probation and parole between now and then. We have had this situation come up before, and I think as long as you're already a resident of whatever state you're in, it's a lot easier. I think the ones that are harder is if you're trying to move.
Right.
It is a lot easier.
It's a probated offer, so it should be.
Yeah. All right. So Mr. Tang, let me get back to where I was. Do you feel like you are under the influence of anything today?
No.
Do you feel like your judgment is impaired for any other reason today?
No, I don't.
All right. Are you satisfied that you have had adequate time to discuss things with your attorney?
Yes.
All right. Mr. Tang, the offer from the Commonwealth is as follows. Counts 1, 2, and 3 were originally in your indictment. A criminal attempt to commit murder, which would be a Class B felony. The Commonwealth agrees to amend each of those to wanton endangerment in the first degree, which goes down to a Class D felony. And on a plea of guilty to each of those counts, would recommend a 5-year sentence. On count 4, tampering with physical evidence, that is a Class D felony. On a plea of guilty, the Commonwealth recommends a sentence of 5 years. Each of those sentences on counts 1, 2, 3, and 4, as amended, would be concurrent with one another for a total recommended sentence of 5 years. The Commonwealth agrees to probate that sentence under supervision of probation and parole or the equivalent agency in your home state for a period of 5 years. A specific condition of your probation would be to not have contact or communication with the victims in the case or the immediate families of the victims in the case, and the weapon and ammunition that were used would be forfeited. Do you understand that that is the offer of the Commonwealth?
I do understand, but how would I keep contact with my children?
Yeah, Judge, I'll talk to Risa about that. He does need to be able to see his children with, visitation. We just need to figure out a third party and not this lady to be involved in that.
Yeah, I think
it's okay for him to see his children. I don't think anybody's got an objection to that. We just
I don't have an objection to that.
figure out how to do that.
That's doable. And I tell you what we'll do is just, if you all can't, come up with some way to put, and you may not be able to, or you may not think of it, but some way to put that in writing between now and whenever we do the sentencing, we can kind of put some language in there to, I don't think the upshot of this on anybody's part is to try to keep him from visiting with his children. So that ought to be doable. Okay. All right. So Was that your only question on that end, Mr. Tang?
And they've agreed to give his phone back to Judge.
His phone?
Yes.
All right, all right. Let me just.
Well, I got two of them to be exact.
Okay. We'll take care of it.
Did you
All right.
ask them about the question that I had asked you before? And you said you would talk to the prosecutor to find out if they would agree or not?
Let's talk about that after we get off of here.
Okay.
Let's go ahead and get the plea done, okay?
Yeah, yeah. Mr. Tang, let me also ask you, sir, and I've already asked you this before, but we've gotten off sidetracked a time or two, so I want to be sure. Do you feel like you have been promised anything to get you to plead guilty other than what you and I have just discussed that the Commonwealth is agreeing to recommend in your case?
No, I wasn't promised anything.
All right. Have you been threatened by anyone to try to get you to plead guilty?
No, I haven't been threatened by anyone.
All right. Mr. Tang, are you acknowledging to me that on the second day of July 2020 in Barron County, Kentucky, you committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, you wantonly engaged in conduct that created a substantial danger of death or serious physical injury to 3 other individuals, which led to 3 counts?
Yes, sir, I understand.
All right. Are you also telling me that you are acknowledging that at that same approximate time and place, you committed the offense of tampering with physical evidence when, believing that an official proceeding was pending or might have been about to be instituted against you, you destroyed, concealed, removed, or altered physical evidence that you believe could be used in any such proceeding with the intent to impair the availability of the evidence?
I think he said yes, Judge, but there's a lot of background noise.
Yeah, that was the
Yes, sir, I
jail.
understand.
Yeah. All right. Ms. Gardner, is it all right with you if I just write your name in? The offer that I have hadn't been signed by you, but obviously I
Yes,
recognize
Judge.
your all's template there. Okay. Mr. Tang, here's what we're going to do, okay? I'm going to accept your plea of guilty to counts 1, 2, and 3 as amended, as well as to count 4, and I'll enter a judgment accordingly accepting that plea. Let's set this for a final sentencing. And Mr. Simpson, probably what we're going to need to do is maybe, I'm sure you've been through this before, but, get on with probation and parole and try to work out for him to, to try to streamline this process. But I will set this final sentencing for, I don't mind to get it out into June sometime, just to make sure we have enough time to do everything we need to do.
Yes,
So
sir, that's fine.
I'm thinking maybe June 21st.
June
Yeah,
21st.
that's
What
fine
time,
with me.
Judge?
That'll be fine.
All right.
What time?
We'll do 10 o'clock.
10 o'clock.
I mean,
He can appear by Zoom for that since he's in Florida.
Yeah, I don't have a problem with that.
Okay.
Judge, can I get a phone number for Mr. Tang?
Yes, sir. Mr. Tang, can you fire off your phone number for our probation officer?
Yeah, it's 954-728-0683.
Thank you.
You're welcome.
All right. So, Mr. Tang, you and Mr. Simpson can talk about any of these, these kind of loose ends that you all need to tie up. But in the meantime, I'm going to set your sentencing for June 21st, 10 a.m. We can do that remotely. It's fine with me. And then Mr. Simpson, you're going to get me the motion to enter a guilty plea, right? Or just e-file it. That's fine.
Yes, sir, we'll do that. Mr. Tang, if you'll call the office as soon as you get off of here, we'll arrange that.
All right, is that a Monday also?
That will be a Monday. Yes, sir.
Okay, just want to make sure. Yes, I'll call you. Thank you.
All right. Thank you. Good luck, sir.
Thank you. Thank you. Bye.
Let's see. I got Hart County Jail on here. I'd like to see if I can't. I think I just have 2 people over there.
You got Barron County on there too, Judge. I've got Mr. Bruton, which I think we're going to reset.
Oh, okay. Well, yeah, we can do that real quick. Bruton. That's the only case you have left?
That's the only one I got left, and I've gotten an offer from Mr. Gardner. I just need to have time to talk to Mr. I think I've gotten my last and best offer.
All right.
That's correct.
Miss Bonnie, can we get Michael Bruton? Mr. Simpson, when are you going to want to do that?
Judge, my only concern is that I've got a trial starting May 11th in Warren County. I just need the time to set up a Zoom. Probably maybe sometime around the first week of June, second week of June.
Well, I mean, it's kind of a long way away, I guess, but we just did Mr. Tang on June 21st. I don't know if you want to wait that long. I think Mr. Bruton's, he's serving us. So,
Yeah, he's a stadium. That'll be fine, Judge.
I mean, that should.
Michael, I'll be in touch with you.
All right. Now, here, the thing is, yeah, we ought to be able to do those at roughly the same time. So let's do 10 o'clock.
We'll set up a Zoom with you, Michael.
All right. Thank you.
Thank you, Judge.
You bet. That's June 21st at 10 o'clock.
10 o'clock.
All right. Thank you.
Thank
you. All right. With Hart County, I've got Brandon Coy and Adam Kinslow. I do not care which one of those we talk about first, but let's try to go ahead and let them get in and out.
Kinslow, sir.
Mr. Kinslow?
Yes, sir.
Jumped on here twice. It's hard enough to get him on here once.
And Your Honor, I'm going to be representing Mr. Kinslow. His was one of the cases that just recently transferred to me, and I did not realize he was in Hart County Jail until I spoke with his wife late Friday afternoon. So I was going to request that we set another pretrial conference so that I can get up to the Hart County Jail this week to talk to him about his discovery and his offer.
All right. Forgive me if you will. I was busy looking at something. Did you give me a specific day you wanted me to move that to?
I can actually get to the jail this week. Once I found out it was late Friday night, and I didn't think that they would let me in on the weekend. But I can meet with him this week. If the court wants to set it over for next Monday, that would be fine by me. Or if you want more time to set it over, depending on what Monday looks like, is fine either way. But I know I can meet up with Mr. Kinslow this week. I can make it to the jail now that I know where he is for sure.
Sure. Okay. Well, we might as well do Monday. I mean, they're all going to kind of look a little bit rugged for the next little bit. So it's all right. 1 o'clock on the 3rd.
Thank you, sir.
Hey. All right. Thank you. Brandon Coy.
Judge, on Mr. Coy, I don't have anything to report. Greg, is this your client?
It is.
Okay.
Uh,
I was going to suggest, he's got a co-defendant, Ashley Woosley. We had plea negotiations with her that fell apart, and she's hired another attorney, but she's scheduled for May the 10th. I'm trying to keep these two together. It's likely if we ended up trying this case that I would try them together. So Judge, I was going to ask if we could put him on May the 10th. Miss Woosley is going to be on the same day, and I could talk to Greg before then about trying to resolve Coy's case.
Well, Mr. Berry won't be here on May the 10th.
Okay.
If we did the 17th or the 3rd.
I mean, either one's fine with me, but I don't know that it'll bear much fruit to do it on the 3rd.
Okay. Okay.
Well, if he's not going to be here, I guess the 17th will be fine, Judge.
You're not going to be here the 17th, Mike?
No, he's going to, Michael will be here on the 17th.
Oh, okay.
I'd say we could put it on that day.
Yeah. Yeah. We can go over to May the 17th at 1 o'clock.
Okay, Judge.
All right. See you then. All right. I believe that's Hart County taken care of. All right. I think I have Miss Bartell on here now if Miss Fugate still hadn't given up on me.
Still here.
All right. It's hard to get back into rotation. Miss Bartell, can you hear me?
Yes.
Oh, I'll be darned. I might regret asking this given our challenges, but do you have a camera on whatever you're using that you can turn on?
Yes.
All right. I'll make things more complicated, but I prefer to be able to see you. Okay. Hey, Miss Bartell.
Hey.
We've got Miss Fugate on here. She's your attorney. And I just wanted, I like to be able to see people when I'm talking to them, especially on the Zoom. So I just wanted to be sure that I was talking to who I thought I was talking to. What do we have in mind on her case?
Your Honor, we were hoping we would be able to resolve the case. It's not looking like we're going to be able to. So I don't know if you want to go ahead and start looking at trial dates. I'm not sure how you're handling that with people out of custody.
Yeah. Neither am I. Just kidding. Let's see. Miss Gardner, where are you? Is this yours?
I'm here. Yes,
This
it
is yours,
is.
right? So, do we have any of these other ones? I know that we've had some of these other ones set, and then I think they've, probably
We do.
a whole
We
bunch of them have
still,
worked out, but
I think we have some set in 2 weeks in July, or 2 set different weeks. I don't think that she could be tried with, I'm trying to get to the calendar so I can see. We have some set the week of the 20th, 21st, and 22nd. And I think that there was maybe another date set for 1 or 2 of them on July 13th, 14th, and 15th. I don't care to put them on one of those days, but I know that we have so many cases that might bump hers due to either involving a child or someone in custody.
yeah. And Miss Fugate, that's what we had done was, I've never been one that liked to set multiple trials at one time, and but just the exigencies of the circumstances that we've been facing have caused me to do that in the summer months at least. So as Ms. Gardner is alluding to, I've got like a stretch in July of 3 weeks where I've got, I don't even know how many cases set, the bunch. And we're just gonna, with the understanding that as we got closer to it, we'd have to weed through them and see what needed to be tried. Some of those folks weren't in custody when I said it, and they might end up in custody and that kind of thing. Some of them have child victims and that. So anyway, I don't have a problem with setting hers if you want me to in that period of time, and we'll just do our best and hope, hopefully we can do it.
Okay.
Why don't we could do the July 28, 29, and 30th. We could do that.
That should work, Judge.
And then if you wanted to put it on for a pretrial, the rules are that you have to have a pretrial real close to the trial, but what we could do is maybe do a pretrial on July the 19th, and then if, so that we could kind of be able to give you a better picture of where we stood moving into that next week, and then if we needed to reschedule that pretrial.
Judge, could we do July the 12th? I do have trials set that week that may go, but if for some reason they don't go, I will be out of town if possible. Emory's going to have a tournament to go to, so we can do the 12th.
The reason I didn't want to do the 12th is because all those other pre-trials for those other trials are going to be on the 14th, which is a Wednesday. But you remember we set them so that they would be the day before we started all those other trials because they had told us from the Supreme Court that we had to do a pretrial within 48 hours or something of the trial date or something. I don't remember what it was. But I mean, I can put it on the 14th if you want to. That's a Wednesday, but
I don't
that's when
care
all
to
those other
do,
cases will be.
I don't care to do the 19th. And I'll just, I'll make a point to talk to Ms. Fugate beforehand, and
That'll work.
Yeah, I'd
if we
expect.
don't have anything to discuss, we'll just go to trial on the 28th. If
All right.
that's the case that goes.
I got you. So 7/28. Pre-trial 7/19 at 1 o'clock. All right, Ms. Bartell, did you hear me there? We'll be back on your case July the 19th at 1 o'clock, okay?
Okay.
You need to be sure you stay in contact with your attorney and be where she can get you if she needs you, okay?
Okay.
All right, thank you.
Thank you.
All right.
Judge,
Mr.
could we
Gate,
call,
Thank you.
sorry,
Sorry.
could we call Terry Carroll? I know that Ms. Myers indicated that she was going to be stepping in that case, and we haven't had any discussions. So I'm
Yes.
assuming we'll probably need another pretrial on that.
Yeah. Hey, Terry. All right, this is 20 CR 371.
And Judge, I got this case last Monday. I found out about it, and I was able to catch up with Ms. Carroll. And in doing so, I thought we were just going to be setting this over to Monday because there was an offer that hadn't been discussed with her. But when I looked at the case, and after having an opportunity to discuss the case with Ms. Carroll, I filed a motion to dismiss. I know that I wasn't within the appropriate time to file that, but I kind of wanted to signal to with.
I've not received a copy of that.
Okay. I think somebody's, okay.
Hey, yeah, guys, we need, everybody turn their mics off, please.
I filed a copy of that through the e-filing system. I apologize if you didn't get notice of that, but I'll go ahead and send you the email too with a copy of that. But I basically wanted to go ahead and just file it so the court knew the direction that we were going with it at this point.
Yeah, I saw it. Of course, the reason that I was able to see it's because you tendered an order. So, that popped up into my workload and I was able to see that the motion had been filed. It's neither here nor there, but this e-filing is really good. And then it also doesn't do some things that I wish it did, but I wish it would send me a copy of all the motions that I wanted to get a copy of, but not send me a copy of the motions that I don't want to get a copy of. But I can only opt in or out of all motions. So I've opted out of getting all motions because, most of them you don't need to see immediately. But anyway, long story short, I knew that you filed it. I've read your motion. What I was going to propose, similar to the case I talked to Mr. Berry and Mr. Gardner about earlier, which he's filed a similar motion, is that we were going to put that on for May the 14th. The morning of May the 14th, and the Commonwealth was going to file a response to the motion, and we could talk on that day and see what it is that where our path forward, whether it was what we were going to look at or what we were not going to look at, and that kind of thing. We've done. I obviously haven't had any of these with Miss Myers, but I've had several of these over the years, and so. I think I have a handle on how to proceed. I've done a few orders and things like that address the legal framework and the legalities of it and all that. And I'd be happy to, Ms. Gardner could probably share one with you. Or I could send one to you to see how I generally approach it. But what we could do is get together on May 14th is the upshot of this, and have a little bit of time to talk about what we're, how we're going to make this decision. Does that make sense?
Yeah.
I don't necessarily oppose that at all, Your Honor. The only thing that I'm a little concerned about is that I may still be in trial up in Hardin County on May 14th because there's 4 co-defendants on that case. And depending on how it goes, I may be in trial. I'm hoping by sentencing. Well, I hope I don't get to sentencing. It would be nice if I'm not in trial, but I may actually be tied up on that Friday because of the number of co-defendants I've got in that case. But I don't mind setting another date on it. And I don't mind even setting it for the 14th with the understanding that if I'm tied up in trial, we might have to move that.
I will definitely not hold it against you if you're stuck in a trial. And, you know, as long as, particularly as long as, you know, maybe I guess the other folks in your office will know whether you're still in your trial or not, just so that they can alert Ms. Gardner or alert me. But we've set several things that morning, a couple of revocation hearings and stuff like that. So, I mean, you know, we're going to be getting together no matter what. So it's not going to inconvenience anybody. If we can't do it, we'll just pop it over to the next Monday or something.
That'd be fun.
Okay.
Judge, I haven't seen this, but
I'll send you that motion. I apologize. I thought you got notice of it through the
That's
East
okay.
filed it. So
I did not. And I'm imagining without seeing it, this is like the motion we handled in Tang, Stephen Tang, Judge.
It is a motion that under the same statutory, you know, provision, the immunity statute. Yeah. All right. So let's do this. Let's go over to May 14th at 9 a.m. subject to council's availability, but and I don't care. I don't know. We really didn't explicitly discuss, but those other cases are all going to be Zoom because they're in jail. So, I mean, I'll be fine on May 14th if we just do it remotely. Okay. I'll set up a link and we'll send it to all the attorneys and then they can forward them out to whoever they need to. Okay.
thank you, Your Honor.
All right, Terry, you got that? Well, your sound's turned off, but it looks like you're agreeing with me.
Yes, thank you, sir.
All right, we'll see you.
And Judge, I see there's a Holden Piercy on here. He was supposed to appear next week, but I do have his paperwork to enter a plea. Do you want to take care of it today, or I can send?
I'm on here.
Yeah.
Yeah.
I mean, that's fine if you want to forward all that paperwork up here to me and one of the DPA folks wants to sit in with it.
I was actually gonna see if I could get an extension on it, Judge.
Oh, what is it, Ms. Gardner? What are we talking about?
It's a rocket docket.
Oh,
He's
okay.
accepted a drug court offer, and he was set. I had talked to his attorney about him personally appearing next Monday at 1.
Oh, okay. Yeah.
Well, what happened?
Go ahead.
I'm sorry, Judge. What happened was I got arrested Friday afternoon, wasn't it, hon?
Yeah.
And I didn't want it to violate y'all's agreement that we was going over, and it was over some checks from last September, and that I was trying to get picked up and everything, and I thought I was already served on them, and I just didn't want it to mess up anything, so I got on here today.
Oh, I see.
I'm not aware of that. It wouldn't mess up as far as I'm concerned if those are the only charges.
Okay.
Yeah, I mean, I think what we might be better off doing is just staying the course on that next Monday at 1 o'clock deal. And I think that'll be, if I understand what he's saying, it's like some older checks. So, you know, it's not like a new charge. I mean, it's a new arrest, but it's not a new charge.
Yes, that's correct.
Yeah. So that, like Ms. Gardner said, I don't think she's going to consider that that's a problem.
Okay.
All right. So I'll see you Monday. Okay.
All right. Sounds good with me. Thank you.
All right. See you. All right. Let me pull my jail docket up here and see who else we got. What about Joshua Binge?
He's my client, Judge. He's in the Berrien County Jail.
Yep.
That is Mr. Gardner's case, I believe.
It is, Judge.
Okay. We've talked about it and talked about offers and counter offers and counter to the counter offer. We don't have an agreement yet, it's the bottom line. I've got another offer from Mr. Gardner this morning that after we talked about it, and but I've not gone over it with Joshua yet. So I would ask if we could put it off for a couple of weeks. Well, I guess we could put it off to next Monday. Wouldn't be that big a deal.
Is there any way that we could go over the offer right now? Like
No,
you could-
we can't talk about all of that while all these other, no, you and your attorney don't need to be talking about the details of your case in front of all these other people and me. On the record, that wouldn't be a smart thing to do. Well, yeah, Greg, next Monday's fine. 2 weeks is that week that you all will be gone. So it's
Okay.
either 1 week or 3 weeks, which I'm okay either way. You just tell me what works better for you.
Yeah, next Monday would be fine, Judge.
All right. 5/3 at 1 o'clock. Okay.
Okay, Judge.
All right. Thank you. Let's see. We got Mr. Depp at the jail. Thank you. All right. Let's see. Mr. Brown is probably on this in part. Mr. Bell's on this one in part. Right? Conspicuously quiet.
Judge, I had given Mr. Bell and Mr. Brown last offer. Hey, Johnny. Yeah. Looks like Johnny's talking to somebody in his office.
Oh. Do we want to come back in a minute? He might be doing another Zoom.
Well, looks like he's talking to somebody just in his office, but I'll send him.
Yeah. Hey, John.
Yes.
There is a request on the table that I take a short break. So I'm going to take a short break and maybe you can wrangle him and I'll be back in about 5 minutes.
Okay.
All right. All right.
Furlong, what did I tell you about hitting that window? Don't hate me.
All right, let's turn this back on. All right. We're back. So when we were talking about Mr. Depp, I believe.
Gunner, could you put us in a breakout room for a few seconds?
The spirit is willing, but the flesh is weak.
I understand. If anybody understands that, I do, Judge.
I mean, I'd love to put you in a breakout room, but even after I went on there and did the tutorial and then came back on, and none of the drop-down menus that I installed on there have breakout room listed as one of my choices.
Well, James, I can tell you, well, I guess without it, but basically, I went back to John on the counter offer that you had given me to give him. He has turned that down and has advised me that it's not going to get any better. So I guess it's a simple question, Judge, is either we take the original offer that was offered to us or we can set it for trials. And whatever Mr. Depp wants to do is fine with me. Do you understand that, James?
Yes.
Or I don't care to talk to you more if that's what you want me to do.
Yeah, because I need to find out what the offer is. I know you said 4 years, but I don't know. I mean, I want to know the whole details about it.
Johnny, Mr. Bell, I would, I personally would feel a little better if you and him talked at least, whether it was, before next Monday, or, I mean, I put it off a couple of weeks, whatever would work for you. Because I want to make sure he knows exactly what he's agreeing to or what he's, giving up if he doesn't agree to it.
Yes, sir, Judge. And I went and seen James a couple of weeks ago when we offered the 4, and I thought I explained it in detail, but maybe not well enough, and I'll be glad to go back and do that again. I think the only question is that James wanted me to counter offer with 3 instead of 4. That was turned down, and we're back to, but I'll be glad to go there and do it again. I'd asked for 2 weeks, Judge. I meant to get over there this past week, but due to busy things going on, I wasn't able to get there.
No, I'm not criticizing you. I'm just saying that he seems like maybe he's unclear about something. So I would want to make sure that didn't.
That's fine,
Yeah.
Judge.
May the 10th would work great for us.
That'll work, Judge.
1 o'clock. Okay.
Yes, sir.
All right. Thank you.
Thank you.
Are you ready to do? You ready to do anything else?
I've got several here in the office. If you want to take any of those up, Judge. Unless you need to finish the jail.
Well, I'd like to try to get the jail finished just so that they don't have, if you can live with that.
Yes, sir.
Do you have any of those people?
Cody Riviera, Judge.
Oh, what is that? Oh my goodness. What happened there? All right. All right.
The only thing I'd like to bring up about Mr. Riviera, if I could, Judge, is, there's been discussions about bonds and different things, and I know in some courts now they're doing approved sureties where individuals come in and have to prove that they have enough property, whatever that property might be, to reach a certain number so that it is truly secured. Would the court entertain any type of bond wherein someone could come up and, if they had any type of property that was worth whatever figure the court wants to place upon Mr. Riviera, to allow him to try to make that type of bond instead of going around on the property bond issue?
Well, those property bonds are complicated animals. And I think, what you're probably referring to is the statutory requirement that you get a statement from the county clerk or the PVA, I think it is, of the value of it. And then you have to get some kind of affidavit of the whether there's any debt on it. And I mean, it's pretty complicated when you don't own your own, when it's not your own property. That the requirements are much less when it is your own property, or like I think it's a mother, father, sister, brother, I think are within that category of being your own property.
What I was alluding to, Judge, is under a surety bond, a secured bond, some jurisdictions at this point are allowing, for example, his grandfather or mother to come in, if they can show that they have vehicles, house furnishings, some kind of substantial property that would meet the amount of the surety, the courts have been allowing them to do that. It's still just a surety bond, but they have to have a listing of those properties to show that they have that amount of money in case, for example, Mr. Riviera violated that and run off, then the court would have the right and the documentation to seize all items that were listed. They're doing that in Monroe County, Cumberland County, some places like that. I was just wondering if the court might entertain that type of bond for Mr. Riviera in lieu of the statutory property bond in his case.
Let's see. Is this Mr. Richardson? Are you doing this?
Yes, sir.
Do you understand what he's saying?
Essentially, yes, sir.
All right. What do you want to weigh in at all?
I mean, I guess it's up to the court's discretion, but I mean, I realize at some point, the longer he sits there, the court will probably reassess, when and how much to amend his bond conditions. Although I'd like to point out that we've been here multiple times and Mr. Rivera has violated his bond conditions multiple times and in other cases as well. Frankly, I don't think there's any bond high enough that's going to ensure that he's not going to commit other crime or do what he's supposed to do while he's out on bond. So I guess whatever my position is, whatever his bond is, I think it should stay the same so we can move forward with this. Because I don't think any surety is going to ensure, just based on my past experience with him, there's not going to be any surety that's going to ensure that he's going to not violate his bond conditions. That's just my opinion.
Well, we do have, we do have a little bit of history that we, kind of tend to make me concerned about the very thing that you're concerned about, in terms of, wanting something to at least be a disincentive to, more so than just a signature on a piece of paper that may or may not turn into something. That's of course the theory, and people disagree. There's reasonable minds differ on the efficacy of even cash bonds as far as that goes. I mean, some people say that those don't do any good. I guess I've never had enough money that losing a few $1,000s wouldn't have stung me. So I mean, to me, and anecdotally, I would think that putting some money up would disincentivize you from misbehaving. It would me, but the long story short, I understand what you're saying. I really would like there to be some sort of tangible, and it doesn't have to be deeds or anything like that, but I mean, some sort of tangible and immediate potential that somebody loses something, if he doesn't do what he's supposed to do. And it doesn't have to be the full amount. Another thing, Johnny, that I was thinking about was that, back when we first started talking about this, he had a letter that he could get into rehab, and that's been a while. So I mean, I would probably also like to see make sure that that's still an option for him, because if he got out, if I did change his bond, that would be something that I would want to be happening, would be for him to be going into residential treatment. And I think that letter that I've got is probably 3 or 4 weeks old at this point. So, I mean, I would want some confirmation that that was going to still be possible.
Yes, sir.
And I can, oh, go ahead.
Well, you know, John, one thing I will say from Mr. Riviera, according to his family and himself, you know, he has had a history of messing up and falling off the straight and narrow, but this is the first time in his life that he's stated that he wants help, that he would accept help. And to me, that's him maturing, and hopefully that's real. But the only way, Judge, if it is real, it'd be great. He'd go get some help. We won't ever hear from him again. If it's not real, then we'll be back up here in the same batter, same picture, and you know, same problems. But the only way to know that is to allow him to have that. He is a younger man. He's not like myself, about half wore out, but you know, he's still got some hope and a chance. And I would just like to somehow be able to do that with as minimum concern to the Commonwealth's office and Your Honor's office and to society. But I do will be more than happy to find another place for him to go. We'll get that together and present that to the court, and hopefully we'll get a favorable consideration.
Yeah, listen, it doesn't have to be a different place. I just want to make sure that there is a place. It could be the same place, but
all right.
You know, and if you can get me that, I'll get to work on it and see what I can do. You know, I like to think that I am a chance giver, and like you're saying, really at some point, the only way that you can give a chance is to give it and see what happens. So, I mean, you know, you're not wrong about that. I mean, you know, you can't, you know, I prefer not to think the most negative thought about everybody that I have evidence to think. So, you know, I've got to, you know, I like to give people a chance to see if they're going to fix their own problems. And, you know, at some point you got to do that. Even when the outcome is uncertain. And in fact, all the time it's uncertain. So, I mean, you know, I agree with you that there's a certain risk involved, and you're not wrong. So, you know, if you can get me something that confirms he's got a bed date, you know, I'll see how far I'm willing to go.
Yes, sir. We'll do that, Judge.
It's just tough when, you know, there's been a couple of fits and starts, and it you know, hadn't worked the way I wanted it to, but I ought to be used to that by now.
Well, I think Mr. Riviera would understand, you know, this be his last bite at the apple, and, you know, you do understand that, don't you, Cody?
Yes, sir. And I just want to apologize for the courts for wasting y'all's time before, and giving me, thank y'all for the opportunity y'all gave me before, and the opportunity to get help if that's possible. I appreciate it so much.
Well, you know, I you know, again, I appreciate what you're saying, and you know, as I don't want to belabor the point, but I mean, you know, you can say it all day long, and really there ain't no way to know whether you mean it or not unless somebody gives you the chance. So, but Johnny, why don't I put this on May the 10th, just so we don't lose track of it. But then if you get me something before then, you know, I'll see what I can do.
Yes, sir.
May 10th at 1.
All right.
Thank you.
Thank you, Judge.
Judge, may I speak for a second?
Who is that? I can't tell.
Andrew Johnson.
Oh, yes.
I have to be at work in like 5 minutes. I was just wondering if we can go ahead and proceed with mine.
What's he on here for? Yeah, hold on just a minute.
Yes, sir.
Judge, that's going to be my case now. It was one of Josh's. It's getting transferred over.
Yeah, I mean, I guess, Greg, it could be something that we were going to need to pass anyway. Are you fairly new getting into it?
I am. I've not even reviewed his file yet, Judge, or talked.
Okay. Yeah. Mr. Johnson, the attorney that you've been working with is going to be handing this case off to a different attorney. So it's probably, we couldn't accomplish much anyway. I guess there isn't much reason for me to make you wait around just to hear that. So why don't we, Greg, you want to go to like, just so you have time, you want to go to like June the 7th?
That's fine.
Judge, in this case, I think the last time we were in court was back in October. I had given Josh an offer at that time. I was willing to amend this to a misdemeanor, and the defendant wanted, some time to think about it. Obviously, the courts got shut down, so he's had a lot more time to think about it than, he was originally scheduled to do. So I think we should be able to get a, resolution of this case fairly quickly.
Yeah. So, Greg, do you need him to, well, he said he hadn't reviewed the file even, so I guess it doesn't know whether there's information to that effect in there or not. But Mr. Gardner says, that, there's a fairly, what he thinks is a fairly palatable offer in the file. So I think he's hinting around to me that he's okay with one more pretrial, but he might not be okay if we don't come up with something by then.
If Mr. Johnson, do you have our office number?
I have a cell phone number.
I'm sorry?
I have a cell phone number.
No. Okay. You know about your cell phone number?
Yes, sir.
Okay. Can you send that to me over the chat on this?
I don't really know how to.
Okay. Well, if you don't mind sending it to me over the air like this, I don't mind taking it like this. I'll tell you what, let me give you our office number. You call and leave your number there, okay? You got something to write an office number down on?
Just sent you my number.
Do what?
Yeah, I just sent you my number.
You did what?
I just sent you my number.
Okay.
You can still write down your number if you'd like.
Okay.
All right. Did you get that, Greg?
Yeah, I'll send him mine. Yes, I did.
All right.
Okay.
So can Mr. Johnson go?
Yes, that's fine, Judge. I'll send him mine.
All right. All right. Good deal. Mr. Johnson, we'll see you on, what did I say, June 7th? June 7th.
Yes, sir.
All right.
Thank you.
Dustin Furlong. All right.
Judge, Mr. Barry and I, we had talked about this case this morning, and I didn't really kind of got somewhat of a counter, but I told Mr. Barry I needed more information, so he needs to talk to Mr. Furlong. And I also know that he may possibly still have some extradition issues, I think. And whatever info he finds out would affect whatever offer I'd make next. So I was going to suggest putting this on again in 2 weeks.
That's correct, Judge. I think there's a hold on Mr. Furlong out of Tennessee.
Yeah.
Okay.
Well, it'll be a 1 week or a 3 weeks, because Greg's not going to be here in 2 weeks.
3 weeks is fine.
All right.
Is there any way we can do it with a week so I can hurry up and get something going? Is there any way?
Well, I don't know. I mean, because I don't know what it is that Mr. Barry's going to have to get and provide to the other team. If it take him longer than a week, then it won't do much good.
Yeah, I think it was Mr. Richardson was going to try to contact the prosecutor down in Tennessee and see what the story is on that. But I don't mind trying to do it in a week. I don't know if we can, if we'll have the information. That could be the problem.
I ain't trying to be smart or rude or nothing. I just want to know. You know what I mean?
No, I don't. I don't blame you.
No, you don't know unless you ask, but I don't know what it is that we're waiting on, so I
I
can't.
mean,
whether
I
we-
don't care doing a week, Judge. I'm just saying that I don't want to come back here in a week. I mean, I got other cases, and so does Mr. Berry. So, I mean, I'm trying to be as fast as possible, but, I mean, we could try a week, but if it's not done, I guess we can continue for 2 weeks after that, I guess.
I mean,
That's fine. Week is fine.
yeah, I mean, I'm at your disposal because I don't know what it is that we're needing to do. So if you tell me you don't think you can do it by next Monday, I'm gonna take your word for it. I'm not gonna, I expect you not lying to me.
But, I mean, let's put it on for a week. We'll try to get it worked out before then.
Thank you, buddy.
All right. May 3rd, 1 o'clock or 7 o'clock, depending on what end of the docket it's on. All right. All right, we'll see you Monday.
All right, thank you, buddy.
Timothy Guess.
Judge, can we do him live?
Okay. Matthew Kingery.
Judge, that's my case.
Who spake? Was that Ken?
It
Yes, Your Honor.
was, yeah, and this is my case as well, Judge. I don't know if this is, I think it's probably my issue. I haven't gotten Ken a global offer on this. We've got the 2 cases pending, and there's a misdemeanor case I've got to speak to the county attorney office about amending that. And there's another F case that wasn't presented to the grand jury this time. So I just need to talk with Ken about trying to resolve all these cases. I have not done that at this point.
So is that something, if I gave you 2 weeks, do you think you all could do on that May 10th?
Yeah, definitely.
That
All
would be fine, Judge. Although, Judge, I would like to ask if it's possible we could get a reduction in his bond.
Can I get an ankle monitor, Ken?
Yeah, an ankle monitor would be fine if the court would be willing to do that.
With the bond reduction, I'll pay the bond reduction and ankle monitor or whatever. I don't want out on just a bond, John, neither one of y'all. I still do got some stuff going on with Daddy, John, I need to get took care of. I mean, with the property and everything, I mean, I've got my personal belongings, what's left out there I need to get, and just a few things like that. I mean, that's why I want an ankle monitor. I ain't trying to get out on just a signature bonding like that. I'm willing to post it 10% or something.
Well, Mr. Gardner, you want to talk about that at all?
Yeah, Judge, I know this case has been, sort of pending a little bit. I think part of it is, Ken getting in, and then I haven't talked to Ken since he's gotten in. And we've got these other, cases out there as well. The issue is, we've had, 4 or 5 charges within the past 6 months or so on Mr. Kingery, and Commonwealth obviously is concerned if he's out, what trouble he might be getting into. So,
Even with the monitor on?
That is one thing that you can say about, you've been in jail now for however long it's been. That's the longest stretch you've gone in a year without getting charged with something.
That's a lie.
Huh?
That's a lie. I went from September to deep February, didn't get no trouble.
All right.
I mean, I'm just asking for ankle monitor, man. John, I do got stuff I need to get taken care of. I mean, I know I've reoffended or whatever, but I mean, I'm willing to give me a shot at the ankle monitor. That way you know where I'm at and know what I'm doing.
Yeah, we'll see. I'll think about it.
Judge, if that's a possibility, I mean.
It is a possibility. I'll think about it.
Appreciate you.
Okay.
May the 10th. Yeah. Mike Lowe.
How are you doing, John?
I'm all right. How are you?
I'm good as be expected.
Hold on just a minute, Mike.
Yes, sir.
You know, I wonder if it came up anywhere along the way there. Hold on just a minute, Mike. Do we have his new case? Ms. Myers?
Yes.
Yeah, I'm sorry. What I was checking on was to see whether or not his new indictment had been worked up yet, because he does have a new indictment, but that has not been processed yet into the, where they've got a file or got it all printed up. So I would think that maybe if I could pass that over to Monday, that file will be worked up, and then I can go ahead and arraign him on it.
I don't have a problem with that. And on the current pending charges, I've sent an email to the prosecutor. I suspect he'll have time to actually look at that email and get back with me on that one too. So.
Yeah, this particular case that we're on today, this 20 CR 216, doesn't have as serious of charges as the new case. So I think the new case will be kind of the 800-pound gorilla, Okay. Why don't we do, just since it's an arraignment, do you want to just put it on at 10 o'clock on Monday? Since
I don't have a problem with that being the arraignment, but we might want to address the new case too, depending on what Mr. Richardson's response is. So, I mean, the current case, not the new case.
Yeah, I would put this in with that other case, or put it on at the same time as the other case, just because, I'm sure that if you all can have any conversation about the new one, this one's not going to cause you to fall out, I don't think.
All right, this coming Monday, Judge.
Say again?
This coming Monday.
Yes, sir.
All right. Is there any way I can get a bond on the other one? I'm not a violent offender. I never have been. As far as my new charges, I haven't spoken to my lawyer in like a month. I'd like to see her before I say anything here.
Yeah, I think that's a good idea.
Yes, sir.
I agree. I mean, I'm not being a smart aleck. I think that's a good idea. But she doesn't have that new indictment yet. She doesn't even know what's in it. I mean, I'd say she has a decent idea.
It's a sealed indictment. I was already told about it by the police.
It's not sealed. No.
Oh, that was not, okay.
Yeah. I mean, somebody may have told you it was, but it's not.
All right.
It just hadn't been processed yet. There were a lot of indictments that came out of this last meeting, and they've done almost all of them, but they didn't get that one done yet.
All right, I understand. Is there any way I can get out on the original bond on that? I'm not a violent offender or anything like that.
No, I know. Well, listen, I don't know what's on the indictment. I don't know what I set the bond at. I don't want to get it all.
I signed myself out last time.
I don't want to get it all catawampus, but listen, I'm going to leave it like it is until we get back on Monday, and then I'll talk to you about both of your bonds. Okay?
So I am guilty until proven innocent then.
Do what?
I'm guilty until proven innocent.
I tell you, somebody's giving y'all bad information about how to ask the judge for favors.
I'll apologize for that.
Huh?
I said I do apologize for that.
I mean, hadn't anybody said anything about you being guilty of anything? I said you got indicted.
Yes, sir. Thank you. I'm sorry. I apologize for that.
All right. I'll see you Monday.
Yes, sir.
Your Honor, can I make a request that once that indictment is typed up, it can be maybe emailed to me rather than me waiting until next Monday to get it in hand? That might hedge things off when I go down this week to talk to Mr. Lowe again, and that way I can kind of show him what we're looking at the arraignment as well.
Yeah, that's fine.
Thank you.
I think it should be ready tomorrow. I don't know. I mean, shouldn't it? Or it might. Yeah, it should be.
If somebody will just email it to me, I'll go in when I do my jail visits with Mr. Lowe again. I'll go over the indictment with him in advance for the arraignment. I think that would be helpful so he understands what he's facing.
No, I think there isn't any reason for him to wait until Monday to see it if we get it ready. So I'll ask them to send it to you when it gets printed out. Okay.
Thank you, Your Honor. I appreciate it.
You bet. No problem. Cody Slaughter.
Your Honor, this is Reese's case, but I understand that there's an agreement in this.
What it looks like. Yes, sir. Mr. Slaughter, let me get you pulled up here.
All righty.
All right. Do you believe that you have an agreement in your case?
Yes, sir.
All right. Will you raise your right hand, please? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right. Mr. Slaughter, I'm going to ask you, if you will, to take a look at the paperwork that I've got and get it up here on the screen. Do you see? Oh, that's the wrong one. Sorry. Do you see this document right here?
Yes, sir.
It's called a motion to enter a guilty plea. It's got your name, case number on it. This is the signature page of that motion. Does that look like your signature?
Yes, sir.
Okay. This is the offer page from the Commonwealth. Does that look familiar to you?
Yes, sir.
And does this look like the signature, your signature on that?
Yes, sir.
Okay. Mr. Slaughter, did you read over both of these things before you signed them?
Yes, it's a 2 years for 2-year probate, correct?
Well, I don't know. Let me check. I hadn't seen it before just now, so I need to read it too. Yes. Yes. All right. So, are you comfortable that you've had all the time you need to talk to your lawyer?
Yes, sir.
Do you understand that if you enter a plea of guilty, that has to be your voluntary decision? In other words, you cannot be forced to do that, and you shouldn't do it if you feel like you're being forced to do it.
Yeah, yes, sir.
All right. Has anyone threatened you to try to get you to plead guilty?
No, sir.
Mr. Slaughter, do you understand that you have the right not to incriminate yourself, and if you plead guilty, you waive that right?
Yes, sir.
Do you understand that you have the right to a trial by jury where, with the assistance of your attorney, you can confront and cross-examine the people that give evidence against you, and you can put evidence on in your own defense?
Yes, sir.
You understand that you have the right not to be found guilty unless the Commonwealth can prove guilt to a jury beyond a reasonable doubt?
Yes, sir.
You understand that you have the right to appeal the outcome of any trial to a higher court?
Yes, sir.
All right. And finally, do you understand that if you plead guilty and I accept your plea, you are waiving each of the rights that you and I just discussed?
Yes, sir.
Do you feel like you are under the influence of anything today?
No, sir.
Do you feel like your judgment is impaired for any reason today?
No, sir.
All right. Mr. Slaughter, The Commonwealth's offer in this case, as you had mentioned before, but I'm going to kind of go through it in detail with you, is as follows. On count one, possession of a controlled substance, first degree, third offense. If you plead guilty to that charge, the Commonwealth would recommend a 2-year sentence. Count two, drug paraphernalia, Commonwealth would recommend a 12-month sentence. The sentences would run concurrently for a total recommendation of 2 years. The 2 years would be, let's see, if you had to serve those 2 years would be consecutive with any prior sentence, but the Commonwealth agrees to probate that sentence, this sentence, for a period of 2 years on condition that you are supervised by probation and parole, a substance abuse assessment, and comply with treatment recommendations, if any, that come from that assessment. Is that what you thought you were agreeing to?
Yeah, yes, sir.
All right. Beyond what you and I have just discussed, have you been promised anything to try to get you to plead guilty?
No, sir.
All right. Mr. Slaughter, again, let me ask you, do you feel like I am making you plead guilty?
No, sir.
Are you pleading guilty voluntarily today?
Yes, sir.
You acknowledge that on July 2nd, 2020 in Berrien County, you knowingly and unlawfully possessed methamphetamine, having at least 2 prior convictions for possession of a controlled substance.
Yes, sir.
Are you also acknowledging that at that same time and place you were in possession of drug paraphernalia?
Yes, sir.
All right, Mr. Slaughter, I will accept your plea of guilty today as having been made freely, knowingly, intelligently, and voluntarily with advice of counsel. Are you going to ask for your to be sentenced today, waive a pre-sentence investigation and be sentenced today?
I get yes, sir.
I mean, that's up to you, but I just figured since, you know, you all agree on what the sentence is, you probably just want to go ahead and do it.
Yes, sir.
All right. All right. Now, let me ask you a question, if you don't mind. Are you on any kind of, once we wrap this up, if we finish it today, are you on any other kind of holds from anybody?
Yes, sir. I serve out July 1st I serve a 10-year sentence out July 1st.
I got you. So, Ms. Myers, did you talk, I mean, do you concur with his waiving this and being sentenced today, or do you think he wants to get sentenced later?
Your Honor, we had spoke previously and I thought he was of the opinion that he wanted to waive that PSI, and I'm in agreement with that as well.
All right. All right. That's fine. I just wanted to make sure that that was consistent with what you and he had talked about. All right. Mr. Slaughter, I've accepted your plea of guilty. I'm going to go ahead then and sentence you as you have agreed to a 2-year sentence with that sentence being probated for a period of 2 years on the condition that you comply with probation and parole in all respects, as we have discussed when we were walking through your plea. I have a probation officer. I'm going to waive your fine and court costs because you're in custody and I don't foresee you being able to pay that right now. We have a probation officer here, and I just want to let him know, Officer Bray, know that Officer Bray, he's in custody and is going to be in custody for what sounds like maybe the next 2.5 months.
Okay. Cody, as soon as you get released, I want you to come up here to the probation office. You know where it's at, don't you?
Yeah, I know where it's at.
Okay. Now we're open right now, Monday through Thursday. So if it's on a Friday, you come to on the next Monday. Okay.
Okay, I'll be there.
All right. Thank you.
Thank you, bud.
All right, Mr. Slaughter. Thank you.
Thank you.
All right. Bonnie, I think I'm ready for it. Is this Miss Myers Jackson? Okay.
Judge, that's my case. We've got an agreement on this, but we don't have the paperwork done yet. I just went over to the jail between morning docket and afternoon and conveyed Mr. Richardson's latest offer on it. We've got an agreement on it, but we don't have the paperwork done.
Okay.
And Ms. Myers Jackson is really wanting out today, if there's any possible way to do that. and have her come back next Monday or yeah, she could come back in person next Monday to do the plea agreement.
Judge, I was going to say that part of the agreement was due to the fact her co-defendant had pled out and some of the circumstances in the case, I was agreeable to dismiss the felony. If she pled to the drug paraphernalia, it'll be 12 months probated for 2 years unsupervised. I was wondering if that could just be written on the docket sheet since there's not a felony involved. But if you want paperwork, we could do it, but I'd rather try to do it today if we can.
Well, yeah, Greg, let me ask you that. I don't think that there's any reason we couldn't do that since the felony is going to be, if I understand correctly, dismissed. She doesn't need to do a written plea. And if put the offer on the record there. So, if she wanted to just go ahead and plead to that felony and get probated right now, we wouldn't have any of these other issues to really be concerned about.
Okay, you understand what we're talking about, Rachel?
Yes, sir.
Okay, do you want to go ahead and just do it right now? Get it
Yes,
done?
sir.
Okay.
Yeah, I need to get home to my kids. I was held for missing court.
And Mike, you're saying unsupervised probation?
Yes, sir.
Yeah. Okay. All right. So, Ms. Jackson, let's make sure we understand each other. If I understand correctly, the Commonwealth is moving to dismiss the felony charge in exchange for your guilty plea to the drug paraphernalia, which is a misdemeanor charge. The Commonwealth agrees to a 12-month sentence, probated for 2 years without any supervision, so that the probation would be conditioned on, basically that you don't have any illegal drug use and you don't get any new criminal offenses, get arrested, anything like that. Okay.
Yes, sir.
And is that what you have agreed to?
Yes, sir.
You understand that you have the right to plead and maintain a plea of not guilty. Nobody can make you plead guilty, right?
I do understand that, sir.
All right. If you plead guilty voluntarily today, you are waiving the rights that you have heard me go over. Do you understand that?
Absolutely.
Do
Yes,
you
sir.
want to ask me any questions?
No, but I do want to tell you, you have learned my lesson on missing court. Never again will I miss court.
Well, I hope you don't have any more court,
Me neither.
at least not in the criminal sense.
No, sir.
But if you do, I hope you go to court. Okay?
Yes, sir. And I can be released today?
Yes, ma'am.
Thank you.
So here's what we're going to do. Are you telling me then that you acknowledge, just so that I can get the factual basis of this in here, that on or about the 18th day of December 2019 in Barron County, you possessed drug paraphernalia?
Yes,
All right.
it was a book of rolling papers.
Okay. Let me ask you one more question, and that is, what will your address be? I need to be able to send you all this when we get it typed up. So what will your address be when you get out?
204 B as in boy, Allen Street, Albany, Kentucky, 42602.
Yeah. So
The same as it was before.
so B and then Allen, A-L-L-E-N.
Yes, sir.
All right. Thanks. All right, Miss Myers Jackson, I'm going to accept your plea of guilty today to the misdemeanor. We will enter a judgment dismissing count 1 on motion of the Commonwealth and adjudicating you guilty on count 2, 12 months, suspended for 2 years, unsupervised on those conditions that we discussed. Okay.
Yeah, thank you, sir.
And you will be released from custody today. Like I said, I hope you don't have to worry about coming back anymore. Okay.
Okay.
All right. Thank you. All right, Mr. Guest.
Judge, we've got plea agreements in all 4 cases, and I filed those this morning.
The picture has got rid All right, Mr. Guest, looks like there are agreements in each one of your cases.
Yes, sir.
Are you prepared to go forward then today?
Final sentencing?
Well, no, just for the entry of the plea.
No, I don't know. I think we gotta do a restitution hearing, don't we? Is that before or after?
Are
There's
you
some
asking?
undetermined restitution, Judge, and we had agreed we'd do that on a separate day.
Yeah, no, that's fine. What I'm asking is, are you prepared to plead, to enter your guilty pleas today?
Yeah, but I don't wanna do my final sentencing.
Yeah, I'm not asking about that. I got to take a plea first before I can even talk about final sentencing. So I haven't gotten to that point yet. I'm not asking you to waive any kind of sentencing.
All right, well, I'm guilty.
All right, well, golly, I wish it was that easy.
Guys, man, told me to accept my actions one time. I wonder who that was.
Oh, it was probably,
At one time, he kicked me out of court.
it might have been, yeah, I don't know. It might have been, I don't know.
Oh, I
It all
think-
runs together.
Yes, sir. I got
All
a,
right.
though, can I ask something?
I don't know what I should say here, but yeah, go ahead.
If I take the guilty plea today, can we push my final sentencing off for a few months? Cause and nothing to do with the plea deal or nothing, but once I get shipped and go to the penitentiary, I don't get a chance to get video. If they don't have video visits, I won't see my kids. So I'm just trying to stay and get things in line, not get out or nothing, but you know what I mean?
Yeah, no, I mean, I'm not in any huge hurry to sentence you if that's what you're asking.
Thank you, sir.
Yeah, because I understand what you're saying. All right, look, let me do this. Raise your right hand for me. Do you swear or affirm that you swear or affirm that you will tell me the truth, so help you God?
Yes, sir.
All right. Mr. Guest, I'm going to go through all these documents with you in a broad sense, and then we'll go through them in detail. But the first thing I want to go over is to have you identify these things. This is in 18 CR 515, a motion to enter a guilty plea. Does that look familiar?
Yes, sir. My handwriting.
And on the second page of that is your signature, I think. Is that your signature?
Yes, sir.
Okay. You also have in that case a written offer from the Commonwealth. It looks a little something like this. Does that look familiar?
Yes, sir.
Okay. And again, signature page is right here. Is that your signature?
Yes, sir.
Okay. 19, oh, yep. I called the wrong case. 19 CR 252.
Yes, sir.
Your motion,
Yes, sir.
signature page.
Yes, sir. My signature.
Very good. This is your the offer
Yes, sir.
and signature page. Is
Yes,
that
sir.
your signature? Right?
Yes, sir.
Thank you. 21 CR 25.
Yes, sir.
Motion. All right. Signature page.
Yes, sir.
Okay. Offer sheet
Yes, sir.
and signature page. Is that your signature?
Yes, sir.
Very good. Thank you. Last but not least,
Yes, sir.
all right, and your signature page on that document is right. Well, shoot. Right here.
Yes, sir.
All right, thank you. And then this is your offer.
Yes, sir.
All right. I know I kind of moved it around on you, but there's the signature page. Is that your signature?
Yes, sir.
Very good. Thank you. So, Mr. Guest, here's my question. Did you read over all this is eight different things, 4 motions and 4 plea offers, 1 in each case. Okay?
Yes, sir.
Did you read over each one of these things and have the opportunity to discuss each one of these things with your lawyer?
Yes, sir.
Okay. Are you comfortable that you've had all the time you need to discuss these matters with your lawyer?
Yes, sir.
Are you comfortable that you understand what you have signed?
Yes, sir.
Do you realize that nobody can force you to plead guilty and that a plea of guilty has to be voluntary and, you know, your decision to make, not anybody else's?
Yes, sir.
All right. Do you feel like you've been forced to enter a plea of guilty in any of these cases?
No, sir.
All right. Mr. Guest, do you feel like your judgment is impaired today for any reason?
No, sir.
Let me ask you, are you satisfied with the time that you've had to talk to your attorney?
Yes, I'm satisfied with my attorney. Yes.
All right. Are you, do you understand that if you plead guilty, you waive the right not to incriminate yourself?
Yes, sir.
You waive the right to have a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt.
Yes, sir.
You waive the right to confront and cross-examine with the help of your lawyer, the people that give evidence against you.
Yes, sir.
You waive the right to put evidence on in your defense.
Yes, sir.
And finally, do you understand that you waive the right of appeal?
Yes, sir.
All right. So going through these one at a time, in 18 CR 515, the charges and the Commonwealth's offer are as follows. Count 1, obscuring the identity of a machine, 500 or more, value 500 or more, less than 10,000. That's a Class D felony. On a guilty plea, the Commonwealth is recommending a sentence of 5 years. Count 2, receiving stolen property, 500 or more, but less than 10,000. D felony, the Commonwealth's recommending 5 years. Count 3, count 4, and count 5 are all receiving stolen property under 500, Class A misdemeanors. Commonwealth's recommending 12 months on each. Count 6, persistent felony offender in the first degree. The Commonwealth agrees to amend that to persistent felony offender in the second degree, and it enhances a sentence from 5 to 10. So all of your recommended sentences would run concurrently for a total recommendation of 5, and then enhanced by the PFO to 10. There would be restitution in that case, which it looks like you all have agreed is $440. The Commonwealth is opposing probation. The sentence in this case would be concurrent with the other sentences that we are going to talk about here today, but consecutive with any prior cases if you have any time on those. And a condition of your plea would be not to contact the victim or victims or family thereof. Do you understand all that?
Except for the consecutive with prior cases, what I got time credited for each one of these cases. I get all that, right?
Oh, yeah, yeah.
Well,
I mean, let me ask you this. Are you still, do you still have any state time that you're doing?
No, I'm a county inmate, and I've done 6 months on that one as a county inmate, and I got quite a bit of time in.
Yeah, no, they'll calculate your time, and I'm not, I think that was just in case you still had any like parole time or anything like that. But I mean, I thought you had probably served it all out. I mean, I think they just put that in there just in case.
Standard language we put in there. Judge.
Yeah, it's kind of standard, but I mean, nobody's putting any extra time on you. I mean, if you don't have any prior cases other than these 4 that you still have time left on, then that sentence isn't gonna make any difference.
Well, I got one I served out, but I had 6 months in on, see what I'm saying? Like I got locked up on these cases, and then 9 months later, they revoked me on a state case. So I get that 9 months, 6 or 9 months, somewhere in there. I don't know exactly, but see what I'm saying?
I do see what you're saying. And I mean, here's the problem that I've got is that I don't want to get into telling you how the Department of Corrections is going to calculate your time, because that's their job to do, not mine. But I mean, I'm going to tell them, they're going to ask, and I'm going to tell them that I want you to get all the credit that you have served, you know, like prior to sentencing in this case where you hadn't made bond or, you know, like prior to make bond or after bonds being revoked.
It'll be up to the probation and parole officer that submits my PSI. That'd be who determines my jail credit.
Well, I think that they do the initial calculation. Yeah.
Yeah. So
Yeah.
it'll be whatever they say. I just want them to know I get all of it.
Yeah. I'm not trying to keep you from getting any credit.
Thank you.
And I don't, and the Commonwealth's not either. Bless you.
All right.
All right. So, other than what you and I just talked about in this 18 CR 515, have you been promised anything for anybody to try to induce a plea of guilty from you?
No, sir.
All right. Have you been threatened by anybody?
No, sir.
All right. Mr. Guess, are you acknowledging to me, or well, it's going to take a minute to go through all this. So let me ask it this way. Do you feel like you are pleading guilty today voluntarily?
Yes, sir.
All right. Are you acknowledging that on or about August 13th, 2018 in Berrien County, you committed the offense of obscuring the identity of a machine when you removed, defaced, covered, altered, destroyed, or otherwise obscured a serial number or other distinguishing identification number or mark on an automobile or other propelled vehicle or mechanical device, valued at $500 or more, but less than $10,000,
Yes, sir.
with the intent to render the property unidentifiable?
Yes, sir.
All right, thank you. Are you acknowledging that at that same time and place, you committed the receiving stolen property offense when you received, retained, or disposed of property belonging to another person valued at over $500 or less than $10,000, knowing or having reason to believe that property had been stolen?
Yes, sir.
All right. Then you got 3 receiving stolen property under 500 cases. So are you acknowledging that you received, retained, or disposed of property belonging to 3 other people valued at less than $500, knowing that it had been stolen or having reason to believe it had been stolen?
Yes, sir.
All right. And as far as the PFO, are you acknowledging that you have previously been, you're over the age of 21, were when the offenses were committed, and you are previously been convicted of felonies in Hart, Jefferson, Barron counties?
Yes, sir.
All right. Then, Mr. Guest, this is what we'll do. We'll accept your guilty plea in 18 CR 515. We'll come back in a minute and talk about a sentencing date. All right. 19 CR 252. The plea offer, as I understand it in that case, is as to count 1, theft by unlawful taking $10,000 or more, a Class C felony. The recommendation on a guilty plea is a 10-year sentence. Burglary in the 3rd degree, a Class D felony. The recommendation is 2 years. Criminal mischief 1st degree, a D felony. The recommendation is 2 years. Count 4, persistent felony offender in the 1st degree. The Commonwealth agrees to amend to 2nd degree, and the effect of that is an enhancement of the sentence due to the PFO. The presence of the PFO, the total recommended sentence would be a 17-year sentence. It would be concurrent with the other 3 cases that we are talking about here today. No contact directly or indirectly with the victims. Same deal, Commonwealth opposes probation, and the parties agree to a separate restitution hearing.
Yes, sir.
Okay, fair enough. Other than that, have you been promised anything to get you to plead guilty?
No, sir.
Have you been threatened by anyone?
No, sir.
Are you acknowledging to me that on or about April 14th, 2019 in Berrien County, you unlawfully took or exercised control over movable property belonging to another person that or people valued at $10,000 or more, but less than $1 million, with the intent to deprive the lawful owner thereof?
Yes, sir.
All right. Are you acknowledging the burglary 3rd degree when you knowingly entered or remained unlawfully in a storage unit belonging to another person or persons with the intent to commit a crime?
Yes, sir.
All right. Are you acknowledging the criminal mischief 1st degree when you intentionally or wantonly defaced, destroyed, or damaged property belonging to another person or persons causing a loss of $1,000 or more?
Yes, sir.
Are you acknowledging that you are more than 21 years of age, you were more than 18 years of age when the underlying offense or offenses were committed, and you have previously been convicted of felonies in Hart, Jefferson, and Berrien County?
Yes, sir.
All right, Mr. Guest, I'm gonna accept your guilty plea there. And again, we'll come back to the sentencing question momentarily. 21 CR 25. In that case, the Commonwealth's offer is as follows. Count one, receiving stolen property, $500 or more, under 10,000, a Class D felony. The Commonwealth agrees to recommend a sentence of 5 years. Possession of a controlled substance, first degree, first offense, a D felony. The Commonwealth agrees to recommend a 5-year sentence. Count three, wanton endangerment, first degree, a Class D felony, 5-year sentence. Count four and count five, criminal mischief, first degree, each of which is a D felony. Commonwealth agrees to recommend 5 years. Count six, fleeing or evading, first degree, Class D felony, 5 years. Count seven, suspended, operating on suspended license, a B misdemeanor, 90 days. Count eight, theft by unlawful taking under 500, an A misdemeanor, 12 months. Count nine, open container. Commonwealth agrees to dismiss. Count 10, persistent felony offender. Commonwealth agrees to amend from first degree to second degree, and that is an enhancement of your time to 10 years. The Commonwealth agrees. Looks like we're going to have to set restitution on that case as well. You agree to part of it, and part of it is to be determined. And then the same other conditions as far as opposition to probation, concurrent sentencing, etc. No contact with victims, right?
Yes, sir.
All right. Here, stand up where I can see you, please. Thank you. Other than that, has anybody promised you anything to try to get you to plead guilty?
No, sir.
All right. Mr. Guest, are you acknowledging that on or about the 10th day of December 2020 in Berrien County, Kentucky, you committed the offense of receiving stolen property, 500 or more, when you received, retained, or disposed of a 2005 Dodge Dakota belonging to another person valued at 500 or more, but less than $10,000, knowing or having reason to believe it had been stolen?
Yes, sir.
At that same time and place, were you in possession of a Schedule II controlled substance?
Yes, sir.
All right. Are you acknowledging at that same time and place you committed the offense of wanton endangerment, first degree, when under circumstances manifesting extreme indifference to the value of human life, you wantonly engaged in conduct creating a substantial danger of death or serious physical injury to another person?
Yes, sir.
All right. There are 2 counts of criminal mischief. Are you acknowledging that you intentionally or wantonly defaced, destroyed, or damaged 2 different cruisers, causing a loss of $1,000 or more, and a 2006 Dodge Dakota?
Yes, sir.
All right. Are you acknowledging, Mr. Guest, that you committed the offense of fleeing or evading when you disobeyed a direction to stop your motor vehicle, having the intent to elude or flee, and by so doing caused or created a substantial risk of death or serious physical injury to any person?
Yes, sir.
Were you operating your motor vehicle without a license or knowing that your license had been revoked or suspended?
Yes, sir.
All right. Are you acknowledging that you took or exercised control over property valued at under $500 with the intent to deprive the lawful owner thereof?
Yes, sir.
All right. And are you acknowledging that you are more than 21 years of age, you were more than 18 years of age when these offenses were committed, and you were previously being convicted of felonies in Hart, Jefferson, and Berrien County?
Yes, sir.
All right. We're not done, but we can see the end from here. All right. 21 CR 42. The Commonwealth's offer is as follows. Count 1, assault in the second degree. That is a Class C felony. The Commonwealth agrees on a guilty plea to recommend a sentence of 10 years. Count 2 is not your charge. Count 3, PFO first degree. Commonwealth agrees to amend it to second degree, enhances the sentence to 17. The Commonwealth, again, opposes probation, recommends that this sentence be concurrent with all other sentences discussed on this day. Is that what you believe the offer from the Commonwealth to be?
17 years at 20%, correct?
Uh, yeah, as far as I know, yeah.
Yes,
Yeah.
sir.
All right. And then let me ask you, are you acknowledging that on or about December 28th, 2020, in Barron County, Kentucky, you intentionally caused serious physical injury to another person?
Yes, sir.
All right. Are you acknowledging that you are currently 21 or more years of age? You were more than 18 years of age when the offense was committed, and you have been previously being convicted of felonies in 3 counties?
Yes, sir.
All right, Mr. Guest, I'm going to stop there. Here's what I think we need to do, because there, I don't know what we're going to get into with these restitutions, but it might, take a little bit of extra time. Why don't I don't know if you all want to weigh in on this, but I was thinking maybe to set that in 3 or 4 weeks. And then after we get that restitution done and calculated, then I can schedule his sentencing, but I don't want to do it in the context of the sentencing because I don't want to put it on a Monday and I don't think we'd have time.
That's fine, Judge. That one case, there's a significant dollar amount and there's a lot of, Zan and I will talk, we have been talking about it, and I'm going to try to get with the victims because I'll have to obviously have them testify to some of the amounts. But if we can try to resolve it before the hearing, we'll do that.
Okay.
But it's going to be pretty tedious. So I think we need to set some time aside to do this. Preferably not when we've got, a lot of other cases going on, I guess, and holding everybody else up.
Yeah, no, I'm going to put it on subject to whatever we can come up with right here with you guys. I'll put it on a day that's not a regular day. How does, Ms. Myers, I know you've got a bunch of things going on here. How does like that last week of May grab you? Like the 26th or the 27th of May?
Judge, I think I already have something set on the 26th. I apologize. I'm trying to double check.
Well, we could do the 27th, maybe.
The 27th looks pretty open.
Okay.
The 26th may take some time. I apologize. But the 27th, right as of now, it looks wide open.
All right. Well, what I can do is we can go ahead and get Mr. Guess's PSI and stuff like that kind of in the works, but I'd like to go ahead and do this restitution. And then when we have the restitution, then I can schedule his final sentencing. And I think that probably goes along with what he's asking me to do anyway.
I think I got a PSI on file. Ain't they good for 3 years?
They'd have to update it, But you're the one that's not in a hurry.
Yeah, you're right. You're right. Correct.
Don't be talking me out of stuff.
You're right. Correct.
I'm sure that if they can adapt your old PSI, they'll adapt as much of it as they can. All right.
All right. Am I done?
Well, yeah. So let's set this for May 27th. I think we can do it. We can do it remotely because that'll be best for the, unless you guys decide that you want to do it in person. I don't see any reason why something like this can't be done remotely.
Does my final sentencing got to be done in person?
No, it doesn't have to be.
Oh, okay.
But I'm not going to schedule it yet. I'm going to schedule this first.
They said something about victim families talking. I didn't know if it was in person or how that worked.
They said something, what now?
Somebody talking or something?
Judge, what I told Ms. Myers was in the assault case, Mr. Pointer has an attorney, and I've been communicating to him, and the victims, Mr. Pointer's family may want to say something at the sentencing. So I'm going to get back with them on that, but not until we actually set a date.
Sure. Well, why don't we do this? Why don't you find, if they want to do that, you can tell me when we come back and get back together on May 27th. And that way I'll know what kind of hearing to set.
Yes, sir.
All right.
Thank you, sir.
We're going to do 9 in the morning on May 27th.
Thank you.
All right, thank you. I hope you're right. All right, Bonnie, is that got you?
That's all I've got, Judge.
Thank you. I'll see you in the morning.
See you in the morning, Judge. Bye, Judge.
Lord, that took a minute. All right. Mr. Bell, I know you had a bunch of people. I don't know where we stand.
Your Honor, I've got, four different ones, three that's, here wanting to, it'd be fairly quick.
Yeah, go ahead.
The first one I've got, Your Honor, is Mario Frazier. He's the only individual that isn't here, Your Honor. His wife or fiance or whatever just had the baby, and he isn't present today because he's at the hospital with the child and the mother.
Your Honor, that's John's case. He had to step out. He left a note to say that there had been an offer sent, but he hasn't heard anything yet from Mr. Bell.
We went to the discovery last week, Your Honor, when I talked to Mr. Frazier. He came in and everything. I haven't been able to meet with him this week due to the fact that, she's been at the hospital and had delivery and stuff. So he's supposed to be back in sometime this week, and we'll review that and see if, what our next step is.
Can I put you on that May 10th then?
Yes, sir.
All right, May 10th at 1 o'clock.
And if it please the court, Your Honor, the next case would be Stevie York. He is present here in the office. It would be my intentions to file a suppression motion in that case. I haven't gotten it done yet. So we would ask for maybe 30 days to get a suppression motion filed.
Well, all right. I guess I can put that on for May the 24th, and you can have whatever you're going to file filed, and then we'll set it. Okay.
Yes, sir. Stevie, free to go. Come around here so I can see.
All right.
You free? Okay.
Yep.
Next case I've got, Your Honor, is Brandon Bradshaw. That's Miss Gardner's case. See, Steve.
Thank you, John.
Your Honor, I have been contacted several times by some individuals that wanting to speak to Mr. Bradshaw, and we haven't set that up to this point. And I guess all I need to do is get with Miss Gardner and get a meeting set up between her and Mr. Bradshaw, which Beaver, Your Honor, so that we can get the case hopefully resolved. And I think Miss Gardner knows who I'm talking about and what I'm talking about.
You want to, I guess, with May 24th, give you enough time to do that too?
Yeah, would you want to meet here maybe this week or next, Risa?
Just call me.
Okay.
It depends on the day.
I'll call you tomorrow and we'll get it set up.
Okay.
You're free to go, Beaver. Sorry, head wish on, buddy. All right, buddy. And the last case I've got is Tyler Lee, Your Honor.
Thank you.
In Mr. Lee's case, Your Honor, there was a conflict that arose. We're trying to deal with that. I would ask the court to give me 2 weeks on Mr. Lee.
I'm sorry, there's a conflict as
it's some Rule 1 issues, I guess.
Okay.
May 10th.
Yes, sir.
We also have Joey Price, Johnny, and he had a trial date. He has a trial date set, Judge, on that 18, 19, and 20th date of May.
I
Which
didn't know that we had him on today for some reason.
we won't be able to try it on those days, so I guess we need to get another trial date.
Do we still have any opportunity to resolve that at all, Risa? I know we've talked about it some, but
I guess you talked to me about it when you talked to me about Bradshaw.
y'all want to put it on forward?
Let me put him on,
Or you want to go to that June date?
let me either do the May 10th or the May 24th.
Okay, either way is fine with me, whatever please. We'll go May 10th.
Either works, Judge.
I don't have this, I do have him on the docket for this 20 CR 250, but I don't have that one set for trial. Do we have him set in another case?
Well, I was going to verify. I'm showing that we have that case, and I just want to make sure.
The 20 CR, that's probably why I don't have it on, Judge.
Yeah, the case that he would have set for trial, I set all of those pre-trials for May the 12th.
Okay.
Yeah.
Okay.
I thought
Which
that
I'm gonna
Johnny
end up
had
having to
him
move
in
them
both.
all anyway, because we're not gonna be trying any, we're not gonna be trying any of those.
Right.
So I'm gonna end up having to move all of those to another pretrial date. So if you want to make a note on that one, we can put it on May 24th. No. This is the 250. This is, Johnny isn't on this one. DPA's on this one. He's got another case pending, Price does, that's set for trial later next month, that we're not gonna be able to try because we're trying that child assault case. And so I was gonna have to take it off anyway, but rather than wait till I get to it, let's just go ahead and do an order and set it on the 24th. I don't know the case number. It's 19 CR or something.
18 CR 464.
See, that's what I said, 18 CR 464.
Sorry, I didn't hear you.
No, I didn't say that at all. I had no idea what the number was.
All right.
The only part I thought I knew was 19 and I got that part wrong. Well, in the CR, I got the CR part right, Johnny.
Yes, sir.
I don't want no lip. All right, so I got, so is this, I have a Joey on here. Oh yeah, there you are.
That's
Okay.
him.
Well, you didn't have your camera on before, so I couldn't tell it was you, but now you do have your camera on. So
Oh, I see him now.
yeah.
Oh, you didn't come see me, bud, okay?
Yes, sir.
And then Denise, who's got this one for you guys?
I'm showing Xanda has this one.
All right. Miss Myers, do you mind if I put this on May 24th, and then that way both of his cases will be on that day?
Oh, mine, Joey had indicated he's in the process of hiring Mr. Bell for this case as well.
Yeah, I haven't finished making my payment for the trial yet, but I have the money and the funds to be able to hire him. I just don't have the reliable transportation to make it to him yet. And I haven't had a phone until now to be able to call him and let him know anything.
Well, that's fine, Judge. If he comes in to see me, we might have them all and be able to take care of it. If we just leave them on the 24th, we can.
Yeah, I don't want Miss Myers to be, treading water on it for no reason.
Oh, I don't either.
Mr. Price, Officer Bennett would like to remind you of your next report date, May the 4th, sir.
Yes, sir. I've been having problems remembering that. Thank you.
You're welcome.
Well, you don't want them to have to remind you the hard way.
Oh yeah, he's on. He got on to me last time about it because I was couple of days late reporting. I've been making sure I've been keeping that in mind.
It's getting to where people can't just report to probation and parole whenever they want to anymore.
Yeah.
All right. Don't forget it.
Thank you,
All right,
Judge
thank
Barber.
you.
Good
All right.
day.
Am I dismissed?
Yes.
Okay, thank you, sir.
Thank you. All right. What do you want to do next? I've lost
Judge,
track.
could,
Yeah.
this
Go
is
ahead.
Ken. Could you
Yeah.
call Christian Taylor?
Yes, Christian Taylor.
Yes, sir. Hey, can you hear me?
I can
can
hear
hear
you.
you.
Do you have
Yeah,
a
I'm
camera
here.
on? Do you have
Yeah.
a camera on that machine?
I do.
There we go. I just like to make sure I can see you. All right, we're on Kim for a pretrial, right?
Yes, Your Honor. Judge, I was going to ask for some additional time. I need to sit down with the prosecutor and go back through a potential offer on this. And there's already been an offer made, but I'd like to make a counter offer if it's possible. Secondly, he's been on an ankle bracelet for over a year now, I think. Isn't that right, Christian?
Yeah, it's been 14 months.
14 months. So, Judge, and I know once before you had said that you would consider removing the bracelet if we had to keep putting it out. But I don't think there have been any infractions of him and his home incarceration. So I would ask the court to gracefully allow him to be released from that obligation at this point.
Judge, this is John's case. First of all, I don't believe Mr. Gardner had any notice of any kind of request to modify the bond conditions. Secondly, I mean, if we're talking about it being put out, Mr. Garrett's the one who's just asked for it to be put out further. I would ask if we're going to be putting it out a few weeks that he can keep his ankle bracelet on until that time. Mr. Garrett can file a written motion, or he can talk to John about it and see if it's something he's willing to agree to.
Well, when are you wanting it to be rescheduled to, Ken?
Judge, if you can just give us 2 weeks, I think we can probably resolve that. Obviously, with the court opening up, that'll help.
Yeah. All right, let's do this. I'll pass it to the 10th. I'll take your bond request up at that time. Okay. So, everybody's on notice, I guess, that you're going to ask for it. Okay.
Thank you, Judge.
Passed to May 10th at 1 o'clock. Thank you.
Judge,
And
can we?
Judge, sorry. Did we already take Marquita Lessenberry off the docket for today, Judge? Since
Yeah,
she was
she's not
going to
on.
rehab.
She's not on here.
She's in rehab. Okay, that's all I have. Thank you.
All right. Thank you.
I was going to ask if we could call Jessica Bird. I know she's been on here for quite some time.
Yes, she has been. I agree.
I'm here.
All right.
I have, Tyler Scott was originally my lawyer that was appointed, and he's no longer with the defender's office. And Mr. Berry, and I've tried to contact him 2 or 3 times, and I have not heard anything back from him.
Yeah, everybody's just trying to kind of get their.
Yeah, I was out of town last week if you tried to call then, so.
Yeah.
I've called times before that too, so.
Well, it doesn't matter.
Okay,
Greg, when do you want to?
If you would, send me your phone number over chat, so I've got that in here.
Okay.
And Greg, I don't know if you have, I sent the offer a long time ago, but it's
I
2 for
saw-
2
is that
free
still-
trial averted.
Yeah, does that offer still stand? Is that?
It does.
Okay, all right.
What do you think, Mr. Berry? 3 weeks?
Yeah, that all should be fine, Judge.
May 17th.
Okay.
Ms. Bird, did you send your phone number to Mr. Berry?
Right now,
After you y'all, stay on here so you can give him whatever information he needs, and then you're free to go. We'll see you on May 17th at 1 o'clock, okay?
Judge, can we call Tiffany Court?
We can. Well, there is, but it's in front of Jane Baker's house.
And Judge, she said, it says pretrial conference, but I'm not really sure she's been arraigned. I know she's been in rehab this entire time, and I got a letter here recently that she completed that. So
Yes, she's been doing a real good job of keeping in touch with us. She got arraigned on December the 14th.
Okay.
So it's easy to see why you might not remember it.
Yeah. I don't know who her attorney is, and I haven't talked to anybody about it, but I think with her doing well,
I am.
okay, I think we can resolve it.
Yeah, it was one that was Josh's, but I've got it now. And she has sent me a number where she is, so I can call her at that rehab and talk to her.
Okay.
Can you hear me?
Yes, ma'am.
Okay. I graduated the 10-month treatment center at Mission Teens, and I'm currently in a transitional living facility now in Owensboro, Kentucky.
Okay.
So I'm not there anymore.
How long will you be there?
You can be here as long as you want. They help you get a job and a car and all that stuff. It's not really I don't think you have a certain amount of time, just however long it takes for you to get on your feet,
Yeah. Okay.
So there's not really a time limit.
So have you sent Mr. Barry that number where you are now, or can you do that?
Yes, sir.
Can you?
Yeah, I just sent that to him over the chat.
Super. All right. So Greg, what you want to look at the 17th on her?
Yeah, that'd be fine, Judge.
This is one that if Miss Court is still in the transitional living or whatever she had called that, I don't want to call it the wrong thing. If she's still in that facility or halfway house or whatever we want to call it, then we can do hers on the 17th. We can do it by Zoom,
Okay.
I don't want her to have to drive all the way over here from Owensboro if that's where she's going to be.
Thank you.
I guess, Greg, the only factor before I pop off and run my mouth is if you all have some kind of plea that involves her, entering a plea, then she'll have to make some kind of arrangements to come talk to the probation officer. But I mean, we could give her a different date to do that.
Okay.
I have one question. I am still on parole from a long time ago, and I contacted my parole officer when I completed the treatment center, and I've been off parole for over half a year now. All I owe is $1,500 in restitution, and with getting a job here and stuff, I'll be able to pay that off, and I'll be done with my parole, so I can be sentenced later on, throughout that time. So, but I wanted to complete my parole before I got sentenced on anything else, and all I owe is $1,500 in restitution on that.
Where's your parole out of?
My parole is out of Louisville, but I just called them and they put in a transfer order to move it down to Owensboro. So I should be reporting to them soon when I get an officer down here.
Well, I just talk to Mr. Barry about that and get the timing on it right. Okay. And I mean, you'll probably need to be able to give him some idea of what it's going to take, how much time it's going to take to get this restitution taken care of and everything.
Okay. Yes, sir.
Okay.
Yes.
All right. We can see you on May 17th. And like I said, we can do that on the video, the Zoom. Okay.
At what time, sir?
1 o'clock.
Okay. Thank you.
Thank you.
Judge also had Austin Causeway. I believe I saw him on here earlier. I don't know if he's still on.
Yes, sir. I'm here.
Judge, this was Mr. Scott's case, and obviously he's not been here a little bit Tyler was the last one I talked to about a plea offer. I don't know whose attorney is now, so I think we'd have to put it on for another date.
Who'd you call, Mike? I didn't hear the name.
Austin Causeway.
Oh,
Yeah.
Transferred to me, and I apologize. I didn't have a good contact number for Mr. Causeway. I didn't realize he was actually on this call. But I
can
wasn't,
send it to you in the chat.
that would be great.
Okay.
But I'll be taking over his case. I just got it last week, and I apologize, Mr. Richardson, that I hadn't had a chance.
No, that's fine, but there's another issue too. He's actually got a warrant out for him out of Warren County for absconding probation. I wanted to bring that up to the court's attention. You know, that's kind of hanging out there right now.
Okay. Yeah, well, I didn't know anything about that.
I mean, I just looked it up on CourtNet and I talked to Officer Bray about it. And that's right now, there is a warrant and that's for absconding.
Is there any possible way I could get in touch with him and try and settle that?
I don't know if Ms. Myers wants me to talk to you directly about anything or not, you know.
Mr. Causeway, you can come in the office if you need, Sadler.
Okay.
After this session,
I was trying to get it switched over
hold on,
to.
hold on,
oh, sorry.
hold on. Let
Sorry.
your attorney talk.
Yes,
please.
Yes, sir.
if I could call Mr. Causeway after I'm finished with court today, I will call him today and we'll kind of discuss all of his concerns.
All right. Sounds good.
And can we reschedule this court date to give me an opportunity to kind of go over his discovery and figure out where they were when they left off with negotiations as well?
I mean, that's fine, but I, you know, it's kind of like he's absconded. I think he needs to go report into probation and parole immediately. And I can't order him to do it, but I mean, that needs to get resolved.
Oh, yeah. I mean, I can't, it sounds like he's got a warrant out of another court. So, I mean, I know what I would be saying if I was that other court, which is, you know, you need to go to your probation officer and, you know, do whatever they tell you to do. And if they put you in jail, they're going to put you in jail. But I mean, I can't, I don't have any control over what happens in that other case. So I'm going to put this on June the 7th. But I think, you know, you're going to be a lot better off probably if you are cooperative. I mean, I'm trying not to give you advice because that's not what I'm here for. That's what your
I
attorney
understand,
did.
sir.
And she's asking you to call her so that she can give you advice. So I would, here I am giving you advice again, but my advice would be to call your attorney.
Yes, sir.
All right.
Judge, I told Xanda that I would call Robert Carter a while ago, but I had to step out and
that's
my
fine.
daughter. So I think
That's
he's
fine.
supposed to be going to work or.
Robert Carter.
And we need to
Am I
get
okay to
jury
leave?
trial dates for
Yeah,
him.
yeah. You're okay, Mr.
Okay.
Causeway.
And
Thank you.
I'll contact her as soon as possible or wait for her call.
I'll call you as soon as I'm out of court.
Okay, thank you.
All right. So we got Mr. Carter on here, right?
Yes, sir.
And I'm guessing, I don't know where, Ms. Myers, what do you want to do here? I don't know how much time you've had to get in on this one either.
Well, this one actually was reassigned to me back when it was initially set for trial. So I've had a chance to kind of go through this probably in a little more depth than some of these ones that I've just gotten recently. I had talked to John about this back then, and I think probably what we have to do is just go ahead and set another trial date.
Okay. I also want to point out, you probably saw some reference to this in your file, but there was an in-camera review of his of the witness potential, some of the records that, I mean, I don't know how much I want to say on here in front of everybody, but there was a request way back when pre-pandemic. So it was, yeah, I'm looking at the order, March the 2nd, 2020, where the various places that had been given had been supplying therapy to the alleged victim in the case over the years. And those records have all, I guess I better check just to be sure, but my recollection is that there were 3 or 4 different places and they've all tendered those records. And I was going, the idea was that I would do an in-camera review to see if there was any exculpatory information in those records. And although I never did an order for that, I did do that review, and there were thousands of pages of records, but there wasn't anything in there that would be considered exculpatory in a even in a very broad sense of the word. So I don't know if there's anything else that you all want to talk about with that at some point, but you know, that was why that has already been done, is what I'm trying to say.
I think we could probably talk about that a little bit more in depth at like a final pretrial conference, Your Honor. The only big concern I have, and obviously I won't know whether or not the Commonwealth is planning on calling any of those therapists as witnesses, but if they are, then, you know, I'm gonna have to cross-examine those witnesses, and you know, that kind of gets into, and they may have made a decision that they're not calling any particular therapist, but if they do, I think I need to be able to review records to prep for any cross-examination. And again, we can probably talk about that even a little more in depth as we get closer to a final pretrial conference, but that was just my first inclination on it.
Well, Judge, this was a defense request, and these were for records that were not associated with this case. They were, so the Commonwealth doesn't intend on offering the testimony of any of these therapists at this point. This was an attempt by the defense to try to get into those records. I guess you've reviewed them, found that they're not any exculpatory evidence in that. And so my understanding, those records are privileged at this point, and they're not going to be introduced.
Right. I believe the setting of the whole issue was that, you know, there is a privilege that attends those records, and that privilege would bow, you know, if there is exculpatory information in there, that privilege might bow to, you know, to the defendant's constitutional rights. But the rule is that I do an in-camera review to see whether or not there is. And there, you know, most of it was from a long time ago, and I don't want to say a whole lot because it's been a year since I reviewed all of that. But I mean, at the time, I've still got them all packed up in a secure location in my office, but there wasn't anything in there that was needed to be disclosed. But again, I mean, we can always revisit if that's what you need to do, but it certainly wasn't the Commonwealth wanting to call any of those people. All right. Let's take a look and see what we got. This is a case I'm trying to remember at this point, and with the time that's gone by, I'm not sure even what age the witness is anymore.
Your Honor, the victim in this case is, I would say, close to 18 at this point. I know that she is, I mean, this case has been pending since 17. There was a little bit of time between the acts and disclosure as well. So I think she's 18 at least.
Yeah, I mean, it's been set for trial 2 or 3 different times and had to get continued for various reasons. And not that I don't think it was anybody's fault. Yeah, let's look at, let me try to find something here where we can move this thing along. If possible. I guess what I'm going to have to do, and you know, everybody that got one of these trial dates knew that this might happen. I think I could probably set it in August I have a civil trial. It's like a car wreck. And I mean, I think they all knew that if I had a criminal case that had to take precedence over it, I would just bump them. So I may just set this and bump those guys. August, I'm looking at the 17th. I don't know how many days you want for it. These things usually take at least a couple, in my experience, but we could do the 19th and 20th, which is a Thursday and a Friday, or we could do the 17th and 18th, or any combination of, those. I've got that whole week that I've got a car wreck case set for.
Can we do the 19th and 20th? I apologize, but I have a final pretrial conference on another murder case on August 17th.
Okay.
And Judge, I think that'll be fine.
All right. And we'll do a pretrial in, let's say we'll do July 12th.
Your Honor, can we move that? Can we move that up a week? I apologize. I'm going to be out, or I'm anticipating being out from July 11th to July 22nd for a continuing education purpose.
Oh, okay. Well, the 5th is a holiday, so that's the 4th of July holiday, so we won't be having court that day. So I can do, June 28th.
That'll work.
Judge? Sir?
Yes.
Can we have another video like this then, or will I need to appear in court? The reason why I'm in Lexington, it's a lot easier for me to do it over the video than it is for me to drive all the way down there and then stand a chance of me being late for work. That's the only reason why I'm asking.
Well,
We're an hour ahead.
I mean, I'm not going to have a real problem with doing the pretrial by video as long as there isn't some reason that we have to have you here.
Okay. That's the only reason why I was asking.
Yep. All right. So 19th and 20th. All right. We'll see y'all.
June 28th?
What?
What time, June 28th? 1 p.m.?
1 o'clock. Yeah.
Okay. Thank you.
All right. All right. Thank you.
Thank you.
Judge, could we call Cornelia Stokes?
Yes.
This is Mr. Spears' case, so I would imagine that it's being reassigned.
It is. It will be. Judge, last time we were in court, I think right after I'd submitted a counter offer to Ms. Gardner, she got back with me Thursday afternoon. I was off last Thursday and Friday, so I wasn't able to communicate that to Cornelius. I attempted to call him this morning with the number I had on him and was not able to get a hold of him. But we're just going to need to continue this case and let the attorney handle it. But I got a feeling it's probably heading for trial based on the conversations I've had with Mr. Dokes over the last few weeks, with the new offer at least.
All right.
And this offer is my final offer. It's not going to change.
All right. So who's going to get this one?
It looks like Miss Myers as well.
Okay.
Was Miss Myers assigned, were you assigned Kelvin Austin recently? No, I thought I got a message from you that you did.
I don't think so.
Okay, I could just be imagining things.
Well, and I might have forgotten if I had sent
Yeah,
you.
I don't know. I just thought that someone had messaged me about that case.
Wait, did you say Kelvin Austin?
Yes.
I think you mean Star.
Yes.
Kelvin Starr, I did message you on him.
That would be a conflict.
He's one of the co-defendant, he's a co-defendant in one of these cases. So.
Okay.
Then I will find other counsel for Mr. Dokes.
Yeah.
Okay.
All right. we're gonna put
Yeah,
this,
you may have to go out of the office for that, so.
we're gonna put it on for, oh, I don't know. Let's call it June the 7th. Give y'all time to get somebody. Okay,
Judge, I've got two different Charles Ballards to call. I was going to start off with Charles Ballard, born in 1975, 20 CR 116.
Yes, sir.
Judge, I think the last time we had a court date on this was back in October, so I haven't had any discussions. I believe I sent it off for a while ago, but Greg, was this one of yours?
Yes, I'm always totally confused on these two cases.
Yeah. Are you representing both Ballards?
I've got both of them as far as I know.
Okay. I mean, it's been a while since we even talked about this one. So I mean, I think we'd have to put it on for another day.
Yeah. See, Charles Jr., I believe, has two cases, and then
Well,
Charles himself has one.
Junior has one case on today. I think the other one you're thinking about, he had already pled to, and he's on parole for. But the only two we have on today is Junior's case and then the Elder's case. Anyway, Judge, we haven't really talked at all about this case. We just got to put it on when we come back in person.
that's fine. When do you want to set this for, Mr. Barry? You want to do May the 17th?
Judge, I'd like a different day. We've got that trial starting on the 18th. I'm going to have a stack on the 17th.
Oh, yeah, that's right. That's right.
Early June is fine, Judge. We got to push it.
What
up.
about June the 7th?
Okay.
And this was 20 CR 317, correct?
No, one
No, this is 20 CR 116.
Okay, my fault.
Jason. As opposed to 20 CR 317, which is CJ.
Charles, can you send me a phone number in your chat, on the chat?
Yes, sir. I just did a while ago, Mr. Barry.
Oh, great. Okay. Okay. I wasn't even looking at that yet. So,
All right. So you kids chat between now and June the 7th, okay?
Yes, sir.
All right.
Thank you.
Yes, sir. See you then.
Yes, sir.
Judge, I had Robert Ethier on, and I'm just going to ask if we could put that out to July because he's in Louisville Metro. I don't know if we're ever going to get him here. He's picked up a new assault second-degree charge in Jefferson County. Has various revocation hearings in other places.
Yeah, I mean, probably until or unless he becomes a state inmate, you're certainly not going to get any cooperation from
Right.
the Republic of Jefferson.
Yeah.
I guess I need to know, Denise, who might be getting that one, because
That one's already Greg.
already Greg,
I already picked him up.
AG. All right. We'll call that July the 12th or 19th, July 19th.
Okay.
Could we possibly do the next week in case I get to leave that day if I don't
Yeah.
have a case?
July 26th.
Thank you.
All right. Who's got, Greg, you have CJ Ballard also?
Yes. Yes.
What do you want to ask me about or tell me about in that case?
Judge, I can tell you that in my notes, we never could come to an agreement the last time we were here in January. Greg and I were supposed to talk, but I don't think we have. I don't care to put this on in June, Judge. I need to talk to the officer. I think I have a good proposal. So if you can give us till June.
14th.
I'll be gone that day, Judge, if we could do it a week earlier.
7th. All right. You got that, CJ?
Yes, sir. Is that at 1 o'clock,
Yes.
June 7th?
Yeah. You be sure to talk to your attorney before then, okay?
Yes, sir.
Sooner rather than later.
Yes, sir.
All right. Thank you.
Thank you.
Judge, I have Jerry Pettigo. I know Xanda and I have gone back and forth on this today. I think we've got an agreement in the case. I've sent the paperwork to her. I'm sure she's got to send it to her client to get it signed. So we can have just another day to come back.
That's correct, Your Honor. I think I'm going to be meeting with him this Thursday. He doesn't have an email, so I can't just email it to him, unfortunately. But I think we've got a meeting set up for Thursday. So I could potentially have it ready to go on Monday.
Okay.
I hope Jerry's a passenger in that car instead of driving.
Yes, sir. Hey, look, there's the driver.
Okay.
I was going to say, unless he's in virtually every other English-speaking country but United States and Canada, he's got to be a passenger.
My boss hired me a driver just to drive me back and forth to job sites.
Well, shoot.
And he also bought me a camper trailer to move inside of his house. He's my sponsor on AAs. So I'm pretty good shape right now.
Yeah, you want to keep that guy happy.
Yeah, that's for sure. He just texted me and want to know where I was at. I told him I had to pull off. We was losing signal.
All right, so you want to do, did you say Monday? You want to do Monday?
I think I can get everything squared away by Monday. Mr. Pettigo and I are going to meet on Thursday, so we should have everything ready to go Monday. I don't know if the court's inclined to let him appear virtually so he can continue to try to work that day, or if you want him in person on Monday.
You want to do it by Zoom, Jerry?
Yes, sir. Please. I appreciate that. That way I stay working.
Yeah, I mean, it's not like I need to see you in person again.
No. I come to your court so much when I'm down there. I have to go to your family reunions.
Yeah, I mean, the county wanted to charge him rent up here. I told him
They did. I got a bill of $32,003. I'm trying to give them $1 a month. I don't know if it's going to work or not.
Maybe they'll buy you a trailer.
Well, my boss bought me one.
Yeah,
it's a camper trailer, but I ain't got nobody impressed.
Yeah,
and it's right beside me. He pulled it next to his driveway, so I can't get away from it.
There you go. I'll see you Monday. All right.
Thanks, sir. Thank y'all.
All right. Lord, who else we got?
Judge, I also had David Hughes. That was Miss Myers' case. I don't know if she's had we had a deal worked out in the case. I don't know if Xanda had a chance to get the paperwork to.
We do have a deal worked out. I don't have the signed paperwork back from Mr. Hughes just yet. And I've had a little trouble trying to reach him over the past week to even tell him to get on. He doesn't have his own cell phone, so I got to route everything through his family.
Do you want to try a week or?
How about we try the 17th just to give you some time to You've
Well-
committed yourself to a lot of stuff here.
The
by Monday.
last time he was on, the court gave him the date of May 24th. What I was going to request is that we just keep that date. And if I can get with him in person to tell him this is your new court date and have those signed forms, I can do a motion to put him on earlier, but at a minimum, May 24th, the court's already conveyed that to him, if you're okay with that, Judge.
I'm okay with that, but when did I tell him May 24th?
You told him that on April 12th.
David Hughes?
Yep. He was set for April 19th. I had inadvertently told him April 12th when I went out there and met with him. And then we called him at the end of the docket and told him May 24th. It was my screw up because I told him a week early. He was early rather than late.
So how the heck did he get on here today? I mean, how did he get on this? It doesn't matter.
He's
May
not
20
on today. We said it on the 19th. I told the court that I thought I would be able to get to his house to have him sign off on
I
every.
got you.
I hadn't been able to meet up with him in person.
I got you. Yeah. I see what you're saying. All right. May 24th at 1 o'clock.
Thank you.
All right. Cody Neal.
Yes, Your Honor.
Yeah. Oops.
I represent Mr. Neal, Your Honor. His case was reassigned to me. I just learned today that I think Mr. Neal is planning on taking the offer, but I'll need to go over paperwork with him.
Sure. What is your address, Mr. Neal? Because your letter came back. I just want to keep current address
It's
on.
108 Lloyd Street, Glasgow, Kentucky.
108 what?
Lloyd Street.
Lloyd, okay.
Yep.
You moved in from the country.
Yeah, my dad and them lost that place out there, so I just went to my mom's.
Okay.
I had to get away from trouble.
I understand. So what day do we want to do this on?
I can have the paperwork set and together by next Monday. If the court's okay with that, I'll probably be asking for a final sentencing date though. But I think I'll have the plea ready by Monday.
All right. So we can go to May 3rd at 1 o'clock.
Do you need Mr. Neal in person for that plea, Your Honor, or is he capable
If he
of
wants
doing
to
that?
do it, if he wants to do it by Zoom, that's fine.
I'm living in Bowling Green. I come to Glasgow when I get calls from U-Turn to do my drug testing.
Okay.
And I can meet up with Xanda then if when I come to Glasgow for my next drug test. I don't know when that's going to be, but I can try to be in Glasgow this week early.
Listen, I'll talk to you about when you're gonna meet up with me. I'll text you on that, okay?
Okay.
Don't worry about that. I'll text you on that, okay?
Let me tell you what our problem is going to be when we get to Monday. Prior to today, we had 54 pretrials on at 1 o'clock. We've probably set 54 today. That's an exaggeration. It's probably more like 45, but still. So, and what we have traditionally tried to do when we've been doing this half in person and half remote is to try to do all of the in-person things right at, to start at 1 o'clock and get everything done before we start doing the remote stuff, because it is just really, really hard to do half of it, to have it hybridized in the room at one time. You can't hear anything, and it's just tough. So I guess my point is I'll be just as he'll probably be better off doing it remotely on Monday than he would trying to come up here in person, just because it will probably be, later in the day on Monday before we're able to get to it. It probably won't be right at 1 o'clock.
Yes, sir. And I also work too, so I'd have to let my work know.
What I think we could do is I will have my Zoom set up. And I mean, people might be able to get on and we can try to do it, but I could give you, if it didn't work, or you could text your attorney or whatever, we could work out and I could say, all right, you can hop off here and try to get back on at 3:30 or something like that, so that people aren't sitting here like, we're just trying to do the best we can, because we've got so many cases just backed up that nothing's happened on, and we're trying to get back in the groove on these, and there's just going to be a lot of waiting. I mean, there's no other way to put it.
I understand, Your Honor. I work with Scott Waste in Bowling Green, so I just have to let them know.
Yeah.
So
I mean, I hate for anybody that's working to have to sit here and all afternoon, but I mean, at the same time, I don't have a lot of choice in the matter.
They let me have off today because I let them know about it. They said just take today off and come back Tuesday. So I let them know. I'm gonna let them know about Monday as well.
But see, we'll be doing the in-person stuff, and then we'll switch over and do the Zoom stuff. And that probably will not be, I mean, I guess I'm going ahead and telling you, that probably will not be before 2 or 2:30. So I mean, it'd be fine with me if he just didn't join up until 2 or 2:30.
Join up.
Let's say 2:30. Let's say 2:30. Yeah.
So join the Zoom call at 2:30.
Yeah, that's fine with me.
All righty. I appreciate it, sir.
Just so you aren't sitting there for, that 2 hours waiting.
Okay. All righty, sir.
All right. Thank you.
Am I dismissed?
Yes. Thank you.
All right. Thanks, sir.
Judge, on Christopher Carmichael, he's on for a pretrial conference. I think he's in a treatment facility, and Xanda hadn't been able to speak with him confidentially yet. And so she was asking for another pretrial conference in this case.
I got you. Where are you, Chris? Where are you, Chris? Oh, yeah, I can't hear you.
He's at Mark and Bowling
All right.
Green.
All right,
Yeah.
Mark. Okay.
Yeah.
All right.
Can you hear me now?
And he's scheduled to be in that program till October 1st.
Oh, okay. So we got a minute or two here. When would you like me to set this?
He's not scheduled to be out till October 1st anyway, Your Honor. The problem I have with a lot of the rehabs, I can call them, but then they have somebody there in the room, so it's not really a confidential communication.
Right.
I'm fine with it out as far as the court is comfortable with.
Your Honor, this is a possession case also, Judge, and I mean, I think we can resolve it pretty easily if we can, get to that.
Wait. I've got receiving stolen property and fleeing evading.
Maybe I didn't look at all the charges.
Yeah,
I don't even
I'm looking
have.
at Rachel Polson, that's why, I'm sorry.
Yeah.
Rachel Polson, yeah. Chris has receiving, fleeing, yeah, PFO. Never
Yeah.
mind.
Chris, when will you have travel privileges at some point?
Yeah, right now they're on it's kind of held up due to the COVID and all that, but would you like to go speak with her or to be in court in person? Or
Yeah. So you can come see your lawyer or leave the premises just, to where you can come meet with her.
Yeah. Soon, but I can't give you a certain date. But right now, everything's on hold right now because of, the COVID and all that.
I understand.
I mean, I can call her. I can call her. I don't.
Understandably so. I think she would rather see you in person, but that's not the hang up. The hang up is that she doesn't want to talk to you with other people listening.
I understand that. I don't want to talk. I feel the same way.
Yeah. But so if you think you'll be able to talk with her without anybody listening, that's what I'm shooting for, whether it's.
Oh yeah, I can make it happen.
Let's get it. I've lost track of who's going to be here. Yeah. You have a chart for John? June. What about June 28th?
That'd be fun.
Your Honor, can I say something without? I can talk without not incriminating myself or even talking about the case. I just want to let the court know my circumstances. That way, it might. I don't know if it being you know, have him bearing on it or not, but, I'd probably feel a lot better about it.
Well, go ahead.
All right, I'm on parole already for 28 years. So out of the past 20 years, I've did 15 out of the past 20. It's not by choice that I came here, it's by parole, but this is probably the best thing that's ever, you know, it's probably the best opportunity that I've ever stumbled up on, you know what I mean? It gives you things to hope for, because once you completed this past October, you know, there's opportunities that come after this. But if, you know, and I've never come in there and asked for a break, or I've accepted my responsibility every time I've been in there. I've never, you know, tried to give y'all a hard time. You know, I'm not asking for anybody to make any decision right now, but I just like for, you know, as far as time, you know, if they give me more, I mean, it's not really, I mean, it matters, you know, but right now I feel like I got more than I could ever do, or, you know, already, but, so, I mean, it's just, you know, it's just like throwing a rock in a wheelbarrow that's already full, you know what I mean?
I do know what you mean.
I'd like to try to do something in my life before it's over. And I feel like it's probably the only opportunity I ever get. And I'm on parole, so once I complete this, you know, the only thing I got to deal with is I'm already going to be on parole, but this is hanging over my head too. So what I'm saying is, if it's a situation where going back is unavoidable, then, you know, I'd almost just say I'd rather just hook up to it.
I know what you're saying. And I mean, I don't know enough about I know nothing about any kind of conversations that your attorney has had or will have with the Commonwealth. And so I you know, it's premature probably to come to any kind of conclusions about that. I mean, I think you need to stay the course over there and try to get the benefit that you can get out of this rehab. Okay.
Yes, sir.
Yeah. And then we'll kind of see how this thing materializes. All right.
Yes, sir.
All right. Listen, I know you got it in you, because, you know, I know that you've made a lot of, listen, I'm not saying anything you don't know. You've made a lot of mistakes, but you're you're a smart guy and you've got people out there that care about you. So what you need to do is, you know, grit your teeth and do everything you can to get straightened out.
I got you.
All right, man.
Yes, sir.
All right. We'll see you on June 28th. Okay.
Let me say it again, June.
It's June 28th. And I mean, if you're over there and it's going to be any issue, again, you can appear by remotely. Just let your attorney know that that's what you're going to do.
Okay. Thank you.
It's better for you to appear by Zoom. Okay.
Okay.
All right. Thank you. See you.
Bye.
All right. Who else we got? Tyler Allen's been in and out of, he's been in the meeting and then he's left the meeting and then he's been in the meeting. And I'm not sure exactly what. He's not in the meeting now, but he might be back in the waiting room because there is a TA in the waiting room. He was Tyler Allen before, or he was Tyler without the Allen. So I am going to jump over here to this waiting room and see if that's him. Yep, there he is. Yeah.
Hello.
Right. Hello, Tyler Allen.
How you doing?
Can you hear me? Can you hear?
Yeah, I can hear you.
All right.
Yes, sir.
All right.
Your Honor,
This
Mr.
case-
Allen.
Yeah, go ahead.
I didn't mean to jump in. I apologize. Mr. Allen's just recently been reassigned to me. I think he was on Mr. Spears' caseload, and I think it just transferred over to me. I didn't have an actual telephone number that I was able to reach Mr. Allen on, so I will send him a message through the chat requesting his number. But I've not had an opportunity to talk to him prior to today.
Okay, as we stand here right now, well, most of us are seated. As we sit here right now, his case is actually set, I think, for trial in June. I don't know if that information catches you by surprise or not. And how that affects, because I'm having a hard time now, and this is not directed at you at all. This happens every summer, because that's when people take vacations and do different things. So I'm having a hard time keeping up with who's available when at this stage.
I think I actually put it down on my trial calendar and it did fit still. So as long as I can get in contact with him and we can exchange those numbers today, I'll be ready by June, assuming there's no competency issue or something crazy that comes up when I first meet with him.
Oh, I don't think you'll have that problem. I will. Right now, what I think we need to do is get it on for another pretrial before then. It's pretty soon. It's June the 9th, I think, is the date for it. And of course, I don't know what everybody's planning on doing, or that we have. This is one of those. That's one of those weeks where we have multiple cases set. So I'm not sure what is going to be tried, but I'm going to leave it on for now. And then I think we probably ought to try to get back together if it's May 24th or whatever day it is to talk about it. Okay. Is that doable?
I'm fine with May 24th. I do need Mr. Allen to respond to my chat box and let me know a number to reach him at.
Okay. I don't know how to really get to it, but okay, I see it now. Okay, I'm sending it to you now.
Okay, thank you.
All right, so can we put it on for May the 24th? Is that what I said?
That'll be fine, Your Honor.
At 1 o'clock?
That's fine. I believe Allen actually has 2 cases set for trial. The June case, the one that will be tried, will that be the older case?
I don't really know what, he's got them both set, and so I don't really know what the Commonwealth's planning on doing, or even if they're going to try this one in.
Yeah, if we try this or one of his cases, it's going to be the assault case, which is the older case.
Yeah, that one's older, right? Yeah.
Yeah.
All right. Ms. Myers, the only other thing I want to bring up is, he gone. If you talk to him, he
didn't give me his number. I don't know if his internet just fell off or not, but
yeah. He's actually was supposed to be getting tested by Julie over here at U-Turn, because I think he was in jail for a while. I let him out, and I think then he picked up this new drug charge, and I think his bond got temporarily revoked, and then I reinstated it, and I wanted him to get drug tested. And he was doing that for a while, and then back in at the beginning of March, I got a report from her that he was not, that his phone just quit working. Like she was calling and she had been able to reach him, and now all of a sudden it was like ringing and ringing. And then it said, Julie says she called his aunt, and his aunt said she would tell him that he needed to get in touch with her, but that was the last she ever heard. And anyway, long story short, as we stand here right now, he's got a warrant out for bond violation, which I wasn't planning on necessarily. Of course, I can't reach through the Zoom screen and do anything about it anyway, but I was planning on just telling him that he needed to get in touch with Miss Atkins and go in there and take a drug test, and see kind of where we are. And that was what I was going to tell him before we wrapped up, that he's gone. I don't have any idea if he gets back in here before. I don't know. If he doesn't get back in, then I guess I'll just leave that warrant. We'll see what happens. Because I don't even know where he is. I don't think he's at his house at where he was before. And then we got Rachel Polston, which is, I think, the one that we had tried to get her in here a month ago, and she wasn't here. Sorry.
Judge, that's one I'll be taking, one of Josh's old cases.
Well, dang it. Greg, what are we gonna do with her?
I don't know. I don't know if we've got